All rise.
The Kosovo Specialist Chambers is now in session.
Be seated. Mr. Court Officer, please call the case.
Good morning, Your Honors. This is the file number KCBC 2020-06, the Specialist Prosecutor versus Hashim Thaçi, Kadri Veseli, Recep Selimi, and Jakub Krsnici. Thank you, Your Honors.
Thank you. Good morning, everyone. Welcome. I note that the accused are all present in court today. Today we will continue hearing the closing statements in this case. This morning we will continue with the closing statement from the defense for Kadri Veseli. Later today we will hear counsel for Recep Selimi's closing statements. We will follow the agenda as set out in the panel's order on the closing statements, which is filing F03639. As a reminder, today's hearing is scheduled to conclude at 16:45 and breaks are scheduled for half an hour at 10:30, resuming at 11, an hour and a half at lunch at 1300, resuming at 14:30, and then a 15-minute break at 15:30, resuming at 15:45. Lastly, since the closing statements are being interpreted, the panel reminds the parties and the participants to speak at a slow pace and to allow the interpreters to catch up and to be conscious of the tendency to speed up when reading from a text. This concludes the remarks from the panel. We will now continue with the closing statements from the defense for Kadri Veseli. Mr. Dixon, you've been allocated 4.5 hours. You have 3.5 hours left, which means that you are scheduled to finish by no later than 1300 today. And you may proceed when you're ready.
Thank you, Your Honours. We left off yesterday in my second overall point on the JCE, and as I said at the end of yesterday, I was going to pick up this morning on certain features of those circumstances which the SPO relies on, but which, when they are subjected to scrutiny, amount to nothing. Bearing in mind that the burden is on the SPO to prove those circumstances, and they can't just be based on mere hearsay, rumor, or misrepresented evidence. So let's go through that list. Number of written orders in the evidence from Mr. Veseli to do anything, let alone anything criminal, none. Number of oral orders from him to anyone, none. The SPO will try to claim that there was one instance of an alleged request to Mr. Kudraku from Mr. Veseli at a by-chance meeting around 1 April 1999, and that is somehow an order. It's alleged to be, from Mr. Kudraku's own evidence, a request to check on some troops, a request that at most nothing else, nothing to do with intelligence. Mr. Kudraku claimed when he came back after doing that, Mr. Veseli wasn't even there, so he couldn't even report to him. So it's nothing at all. Number of orders given to any intelligence persons anywhere to do anything intelligence related or anything else, none. Number of persons shown on the evidence to be reporting to Mr. Veseli, and this obviously does not include rumors and unsubstantiated claims, none. No evidence of a parallel reporting scheme, The SPO placed great emphasis on that when they presented their case through the evidence. They haven't highlighted it in their oral submissions. It's because it's not there. Number of times he signed anything. It's a grand two, Your Honours. One, the FARC agreement in September 1998 to unite groupings and work together. And then two, a general staff document with many signatures on it concerning agreeing to Rambier, which says that a final opinion will be pronounced after consulting the zone commanders. That was in March 1999. That's P227. Two positive, constructive documents for the purposes of promoting and achieving peace. Number of general staff meetings attended. Well, the SBO say there are two. Part of the general staff meeting on the 12th of November 1998, and then the same meeting referred to above when I mentioned the Rambier document, which was signed on 12 March 1998. So 12 March 1999. The SBO referred to these two meetings in their footnote 2083 when they claimed that it was through these meetings that Mr. Vasili perpetrated this JCE. It seems they referred to a third possible meeting as well in April 1999. So it may be three that they are referring to, but that's 3 out of 35 general staff meetings that the SBO have laid evidence on and rely on. And these are meetings of no criminal consequence at all. And there's no evidence of there being any replacement for Mr. Vasili at all of these other meetings, there for him, reporting to him, or that anything was communicated to him each and every time after these meetings. And it can't be assumed, Your Honours, there are alternative inferences such that there was no such ongoing communication. Those alternative inferences are reasonably available, and the prosecution has not dispelled them. Number of persons he appointed or removed, none. Number of orders to, reports from, dealings with the alleged lower-level persons who've been conveniently shoved in to the JCE, that's Mr. Getzi and one other, none. Number of persons interrogated, arrested, or released that he was involved in on any reliable evidence, none. Number of public statements or communiques drafted, or that he fed into, or that were issued by him or shown to him, let alone that he even knew about them, none. Number of regulations that he drafted, participated in preparing, saw, dealt with, distributed, actually implemented in any way, none. And the number of days not in Kosovo in the indictment period, a substantial number, by contrast. We're talking about months at a time. But the number of contacts he made while there with those in Kosovo, whilst abroad, based on any reliable evidence, also none. And here it must be taken into account, without giving any weight to the Serbian intercepts, which we have addressed in our brief and which you'll hear more about. It is not proven that Mr. Vasili is mentioned as speaking on any one of them. For contacts from abroad to the General Staff or others by Mr. Vasili, so when he was abroad going back into Kosovo, the SPO relies only on a book by Pel Refstel for some calls on a single occasion or within the same period, a short period, made while abroad, but these calls were not made by Mr. Vaseli. There's no evidence that he was calling anyone. But Mr. Refsdale was not called as a witness. He could have been. His book is pure hearsay as to how this unfolded. It's not corroborated in any way. There's no other evidence to support this alleged fact that Mr. Vaseli was in constant contact with the general staff in Kosovo while he was abroad. The defense is unable to challenge the maker of the allegation, explore it with him, so we're not just left with what he might have said in a book for whatever reason, but to ask him directly what actually happened, who was involved, what calls were made. The SPO is not entitled to rely on it as a key fact to support their JCE. And this is a repetitive, fatal theme throughout the SPO's case. Number of orders issued while he was abroad or reports received there about anything intelligence related, or decisions that were being taken, or appointments being made, or any actions being taken, even military actions, which are not unlawful, or anything to do with the alleged crimes in this case, or anything of any relevance. None. The list of nothings goes on, Your Honours. The numbers simply don't stack up to a giant criminal conspiracy involving Mr. Vaseli. The circumstantial case is paper thin. Your Honours, my third overall point, and this concerns the rights of the victims and the rule of law. The criticisms of the SPO's case that I've made here against Mr. Vaseli do not for a moment diminish the suffering of those who have been victimized in Kosovo, some of whom are front and center of the indictment in this case, including those who I've referred to in my submission so far, who I wasn't able to name because of the protective measures. But I have them firmly in mind. The ravages and pain of the war in Kosovo have been immense, a sad fact on which all parties to these proceedings agree. And as the experts who were called by Mr. Laws as victims' counsel, that was Dr. Black and Ms. Doon Prison, explained, nearly 65% of the population experienced traumatic events during the war, leading to approximately 200,000 to 400,000 traumatized individuals, which includes the victims recognized in this case, the 155, and countless others. The experts highlighted that research specific to Kosovo indicates that 10 years after the war, and this was taken some time back, the prevalence of post-traumatic stress and depression and pain among the population remains significant, going on to say that in all cases, it was significantly higher than studies from other post-war countries, including wars like Vietnam. That's at page 8 of their joint report. Now, this clearly requires remedial action, including through the work of this court. As the experts emphasize, studies show that a very high percentage, 84% of untreated patients in Kosovo still exhibit symptoms years after the war. And as they said, with all conflicts, time does not heal all wounds. The failure to attain justice only exacerbates the pain and suffering. But that failure is only made worse by deceptions of justice. What victims and their families yearn for, as Mr. Laws emphasized, is justice rooted in the truth and reality. The victims know all too well that the worst form of injustice is pretend justice. in striving to end impunity, which is essential, it's not optional, the truth must not be sacrificed. The innocent must not be punished, and our courts must guard their integrity jealously. Even if it takes over 5 years or longer to get to the truth, as in this case, to that sacred place we must all travel at the end of this trial, now that we finally know how the SPO puts its case on the evidence. Then the length of time expended, while arduous, yes, will be worthwhile. And the ink spilt on thousands of pages of final briefs and the funds spent on the court will be vindicated for victim and accused alike. And more broadly, for Kosovo and all its people, regardless of their ethnicity, as well as for its neighbors, Serbia and Albania. That will make the outcome of Mr. Vasili being on trial for over 5 years and being incarcerated for that time a success, not only because an innocent man is set free, but a precedent will be set for generations to look up to. The last thing I know we all here want is for the future generations in Kosovo and the region more broadly not to trust the rule of law, because it has been trampled on in this case. Your Honours, as the guardians of the rule of law, furnished now, at the end of this long trial, with the SPO's case against Mr. Vasili, it is your Honours who stand in the way of the SPO's wild goose chase to ensure that the interests of justice are not subverted. Your Honours are part of a long tradition of international judges who have been appointed to separate fact from fiction in armed conflicts that have plagued the world. This tradition stretches back to Nuremberg at the conclusion of the Second World War, and it will, we hope, reach far into the future. Your judgment will take its place in that history and not be forgotten. However much the SPO have sought to turn your Honours' heads to convict Mr. Vasili at any cost, we challenge that with legal principle, and we advocate for the rule of law that has underpinned all international courts. Where there is no evidence or very poor evidence, there can be no conviction. One of the enduring qualities of the Nuremberg Tribunal, which did face some criticisms, including over victors' justice, partiality, the lack of any appeal, and the admission of vast truckloads of documents, was that it acquitted some defendants. 3 out of the 22. And I refer to 2 examples of acquittals, obviously not because there's any comparison to our case, but for the purposes of the underlying legal principle applied to evidence presented in any criminal trial. In the case of one acquittal, Hans Fritz, a prominent figure in the propaganda ministry, the tribunal held that although he had made strong statements of a propagandistic nature in his broadcasts, and I quote, "The tribunal is not prepared to hold that they were intended to incite the German people to commit atrocities on conquered peoples. And he cannot be held to have been a participant in the crimes charged. His aim was rather to arouse popular sentiment in support of the war effort." That's at page 526 of the judgment. And in the case of another found not guilty, the diplomat Franz von Papen, the tribunal held that although he used intrigue and bullying as the minister to Austria in the plan to strengthen the Austrian Nazis and undermine those who opposed them, these actions were not criminal. Perhaps not the best way of operating, but not criminal. That's at page 519 of the judgment. Now, as I've noted, even though World War II and the Kosovo conflict, as far as the KLA is concerned, are plainly not even remotely comparable, the universal legal principle of actual criminality being a necessary element for any convictions shines through. Importantly, where there was insufficient evidence that certain accused on trial at Nuremberg actually participated in a criminal way in the alleged war crimes and crimes against humanity, or that it had not been shown that they were central to any criminal plans, they were set free. That showed it was a genuine legal process in which the presumption of guilt was sincerely respected, despite the murders of millions of civilians. It cemented the court's legacy. That has been the same for other international courts like the ICTY, the ICTR, and the ICC. It is unfortunately the acrobatic lengths to which the prosecution case loops when there is no evidential foundation against my client that does send the chills down the spine. It riles against that proud tradition of past and present courts. And one can only imagine how my client must feel in prison, anxious that a case will somehow stick just because a case has been put. It is the words of Cardinal Richelieu, the chief minister to King Louis XIII from the 1620s, which are as unnerving today as they were then. And I quote, he said, "If you give me 6 lions by the hand of the most honest of men, I will find something in them which will hang them." It is the notion of using snippets of information, rumor and speculation, scraps of paper, propaganda, finger-pointing, feuds, untested claims, laced together in ways that suit a certain outcome to convict of a crime, regardless of whether the person actually did it. The American equivalent being a prosecutor can indict a ham sandwich. This danger is especially there in a chaotic guerrilla war, where there are few conventional records, only bits of paper, where propaganda levels and bragging rights are running sky high, both those who were fighting and those on the outside who were commenting on it, and then all the commentary much later on as well. And where fingers are being pointed in every direction, and trust has sadly broken down throughout society. The danger is especially there when the accused is the head of intelligence. That, without needing any evidence, may conjure up the fiction of a mystery man in the shadows who's prone to commit crimes. This generalized thinking goes, well, don't intelligence people collect information on others and use it against them? Aren't they licensed to kill in the fictional style of James Bond with the number 007? You know, these guys all like their numbers, don't they? It is these oversimplified impressions and intuitions, maybe even subconsciously at play, that can be deployed to spin a narrative of guilt. But it remains nothing more than unsubstantiated spin that brings no justice to either the victims or to Mr. Vaseli. Your Honours, now my fourth overall point, which is the staggering irrationality of this prosecution as reflected in the SBO's closing submissions. And even with Your Honours' interventions along the way, perhaps seeking to keep it on track, the prosecution's case against Mr. Vaseli has gotten no better and made no more sense. And I'll touch on this point briefly too, under this heading. Diving into the detail of the brief and the endless footnotes, which I'll come to in my last section today, is, to put it mildly, a somewhat tedious and mind-numbing task. I don't envy anyone who's going to have to go through all of that. This is where the SBO want to drag us all, as they do not have a clear case that is supported. If there was anything in this case, it would be possible to summarize it with a simple, clear, transparent outline of the evidence. There would be no need for a final brief shrouded in a morass of footnotes, which are either irrelevant or unsupported or exaggerated, selective or incomplete, citing only the parts the SBO likes, but the parts they don't like, or where the witness didn't agree with them, or there was other evidence, it's just not there. There should be no need to have to rummage around in the fringes of the piles and piles of bar table documents and multiple hearsay and rumor and gossip in a final brief. Get some proper evidence if you want to prosecute a case. Instead, we are all driven to the edge of madness in having to check every footnote and the precise references it contains, and how it might relate to some other shred of evidence, or not, to try to see whether it may amount to anything. Nitpicking our way through who said what to someone else about what someone else had said to them or not. And it's a prosecution plagued with irrationality in so many ways, and thus not proved. And here, Your Honours, is just the top 10 of that. Number one, starting from the very basics in any criminal case, those who did the DNA examinations and a large part of the pathology were not called by the SBO. Rather, they got others to review those findings and come and talk about those findings. I mean, why? Number two, no original documents produced at all copies, and no effort is made by the SBO to get them, as the Serbian authorities nonchalantly fail to even respond. All of our efforts to say, could we please have these originals? They were so keen for this court to get going, throwing evidence at it. But when we as the defense said, well, can we actually look at the originals of the evidence? Not even an answer. Serbian officials who could have testified about how these documents were collected were dropped from the witness list. And why? 3, witnesses were called by the SBO as witnesses of truth in support of their case, but then they were simultaneously attacked as witnesses the court cannot rely on. We see lists of those near the end of the SBO brief. So they are truthful people when the SBO likes the answers, but liars when not. I mean, how can a court ever be asked to rely on parts of a witness's testimony to convict beyond reasonable doubt, while at the same time being told they cannot be trusted at all on other matters? They were lying under oath to you, concealing crimes. That's what the court was set up to do, to prosecute those crimes. They were concealing them, but yet they're still telling the truth. Defies belief. 4, the SBO have delayed and delayed putting their case on the evidence, saying they are not under an obligation to do so, until the end in their closing submissions. I mean, in what world can a prosecutor say to an accused who's in prison, I will tell you at the end of my case what is the case against you? And then even when they do, as I highlighted yesterday in that one example, we still don't know what their case is. They're still hedging their bets on the hearsay arguments, hoping that one of them will stick somehow. This happened with so many of the witnesses from the KLA and others too. Does the SPO say they are reliable or not telling the truth and therefore unreliable? Or are they also part of this broad JCE, which, as pleaded, could include anyone in the KLA? It's because they've got no evidence that they have to do this. Look at the approach to Mr. Zarapi, for example, which Mr. Misicic highlighted yesterday. I'll only add a few further points. For the first time in their final brief, the SPO submit that he was not in the general staff inner circle to which the accused belonged. Whatever that means. I mean, is there a circle now within a circle? That was never put to him by the SPO to test it or anyone else. The SPO are now saying this for the first time because they know it looks stupid to rely on Mr. Zarapi as a good witness, a good person at the heart of the general staff on the one hand, and yet on the other, how could there be a JC based on collectivity of the general staff, which excludes this honest man who is not a criminal? So in a stroke, a single sentence, the SPO just write him out of the general staff as somebody who was an outsider. But then they still want to rely on parts of his testimony that suit them. Such as, well, he is reliable when he says that Mr. Vaseli's duty would have been to receive reports on collaborators from the zones and inform the legal sector. Suddenly again, Mr. Zarapi is at the heart of it, in the inner circle, explaining how the system worked, leaving aside, of course, that he said that this reporting about collaborators never actually happened, and other witnesses have confirmed this. But the SPO has cited that over and over and over again as somebody who would have known. And how can he know if he's not intimately involved? His evidence is in fact cited some 992 times in the SPO brief. So suddenly he counts again. But then at the very same time, the SPO says Mr. Zarapi is not being honest about his knowledge of KLA criminality. What he says is not credible in that regard. And why not? They say because of his role. So he's lying because of his role. He must have known about crimes. So in the blink of an eye, he's central again. He must be lying about criminality because he must have known because he's such a higher person. The SPO never put to him he was being dishonest. Now, of course, the SPO have to say this, otherwise their whole case on knowledge within the general staff about all of these crimes, this general case, it falls apart. And then, in yet another twist, the SPO digs out that old chestnut, intimidation. Whenever in a corner with nowhere to go, play the intimidation card. With no evidence whatsoever, and that's the key. Of course, if there's evidence of it, it's a different matter. But with no evidence whatsoever, and without ever having explored this matter with Mr. Zarapi when he was here before your honors, they now blurt out, he is lying because of self-preservation in a long-standing climate of intimidation. This is a man that they seek to rely on to convict. They cite him nearly 1,000 times. They use his corroborators' general statements over and over again, but then say his evidence and the truth of it are tainted by intimidation. Well, why would he say anything that could potentially be used to claim that collaborators were pursued by the General Staff if he was so petrified to protect himself? And yet the SBO want not just to ride 2 horses, but 5 all at the same time. They want to say he is a truthful, knowledgeable insider, but not in the inner circle, yet lying about criminality as he must have known in his central role. But he's right about collaborators, but nevertheless he was intimidated. Why do they do this? It's because they have no case against Mr. Vasselli, and they have to flick-flack in all directions, like in a circus tent, to come up with something against him. Desperation leads to the ridiculous in our submission. And if the SBO says to your honours, well, they've had to be innovative in these big testing international cases where there are all kinds of dynamics at play, that is not a credible answer. Where there is no evidence, the only proper course that a prosecutor should follow is don't bring the case. Standards cannot be lowered under the guise of fighting for justice and ending impunity, or for whatever other reasons. Number 5, Your Honours. Persons who allegedly could have given evidence to support the prosecution case, bizarrely were never called as witnesses in the trial. So, for example, witnesses who the SBO claims say my client was involved in some way in any criminality were not called. Instead, they called persons who heard this second and third hand. For the persons taken away that I referred to yesterday, the source witness who the SBO rely on was not called to testify. Why? His account, when relayed as hearsay by another witness who did testify, did not even confirm that Mr. Vasselli was involved. Was this the reason he was not called? He would not say Mr. Vasselli had anything to do with it, which he did not. This underlines again the need to have him in person in court to examine him. There is no reliable evidence other than a collection of hearsay of this allegation and all the others. 6th, the SBO dropped witnesses whose evidence was used for confirming the indictment and who could have provided relevant evidence to your honours. We have calculated that at least 13 witnesses, including internationals, who could have given evidence about important issues, including intelligence matters, were cut altogether. Now, of course, the prosecution has a wide discretion. There's limited time. They've got to narrow it down. But why did these particular witnesses, who could have given this evidence, suddenly not feature when they had featured at the outset to get the indictment confirmed in the first place? 7, key witnesses upon whom the charges against Mr. Vasselli were based from the outset never attended to testify. Your honours will recall waiting and waiting for W4747 to give evidence. And even though he had been very public in the media about his accusations, he did not attend court to face the questions. And yet the SBO still relies on him without any actual corroboration, as though it doesn't matter. I mean, what a comfortable way to prosecute. Let's do it all on paper without exposing your witnesses to being shown to be liars. And why bother even having a trial at all? When the prosecution were just, in our view, too eager to turn 4747 into a written submission and not have him here. I mean, they knew how he was going to be torn apart in his web of lies. Number 8, 3 members of the JCE were called by the SPO to give evidence for the prosecution. Suleiman Salimi, Rustam Mustafa, and Shukri Buya. No explanation has been given as to why they are in the JCE and other leaders are not. Point made already. Nothing was put to them about their contribution when they came to testify, and we are none the wiser today. You would have thought if they are key to the JCE, what the prosecution should have at least tried to do is tease out what their criminal role was and how it related to my client. This irrationality matters as the SPO relies on their testimony to try to convict Mr. Vaseli, without for a moment taking into account that they could be seeking to protect themselves. Not a matter explored with them. I mean, they are alleged to be war criminals, and 2 of them are in fact convicted of crimes after all. How can the SPO with a straight face build any part of their case on them? For example, the SPO relies on Mr. Suleiman Salimi for a part of his UNMIC interview concerning Mr. Vasili's alleged connection to Mr. Getzi, even though the particular allegation arising in that interview is not charged in this case, hasn't been charged anywhere, in fact, it went nowhere. And Mr. Salimi explained to Your Honours in full what he meant by what he had said. But importantly, even if Your Honours don't believe him, as I explored with him in cross-examination, he had every reason to drop someone else into this particular nasty allegation. To say, look over there, intelligence, not me. A key matter that the SPO completely failed to address with him. I had to do it to protect my client's rights. Despite all this, the SPO merely plows on and cites just one small side of his testimony and blindly states that it is reliable to the high criminal standard. There is no other reliable evidence of Mr. Vaseli being in charge in any way of Mr. Getzi and directing him in relation to any of the crimes alleged, or at all. There's also another Getzi that the prosecution sought to link to Mr. Vaseli, not the same Sabit Getzi in the JC, another Sabit Getzi. But they throw it in anyway. I'll return to that later when I do a few of the footnotes. Then, 9th, the SPO's approach to eliciting evidence on documents and admitting them was completely back to front. When there was a witness who could comment on the document, they don't show the witness the document. Or they don't call a witness who could actually answer something about the document. Once again, are they afraid of the answer? Let's rather bar table it. Much safer option. And then just argue that it's all reliable. And when there was a witness who said, look, I know nothing about this document. I mean, how many times did that happen, Your Honours? You remember me standing up and objecting. How many times did it happen? Witness knows nothing about the document. The SPO just pressed ahead and argued, well, you don't need a link to the person there, as long as they can give you some information in general about it. Or even worse, as long as they don't have any reason to dispute the document, it goes in. Often it was purely an exercise in reading the document, having nothing to do with the person there, nothing to do with the provenance of the document at all. But then the SPO also said, when seeking to resist the admission of documents from the defense side, that a link to the witness was indeed needed. When it suited them, they used that argument. There was an objection, for example, at T26886. The essential point without getting into the backwards and forwards of this, is that the SPO have to authenticate and prove these documents if they want to rely on them for the truth of their contents. And the most important thing for Mr. Vasili is whether they've proved he ever received any of these documents or saw them, that any of them passed over his desk, that he did anything about them, that he followed up if he had even seen them, not that that's even shown. The mere fact of the existence of a document, even if authenticated in some way, does not establish it was actually sent, received, reviewed, implemented, acted on. It doesn't show the system in practice if it just sits there on your Honour's desk as a document. Your Honours have to check that for each and every document that is used against my client. I will highlight a few of them as I'm going along, but each and every one has to be viewed through that overall flaw, that irrationality, number 9, in their case. Number 10, we even, in this case, had a person who guarded the accused in prison with access to their cells, who then became a prosecutor of them, accusing them in court, as he called, witness evidence. That is just a top 10, and it is in our submission quite a 10 at that. There's more. International trials, Your Honours, are a rarity, especially nowadays. The opportunity should not have been wasted by the SPO putting my client on trial. What would other countries, like Ukraine, Sudan, Palestine, Afghanistan, Myanmar, Venezuela, Iran, and many others do to have the chance for justice that the SPO has been handed here on a plate through the full cooperation of Kosovo? And instead, the SPO bring an ill-conceived case against only one side in the conflict. It is of significance, we say, Your Honours, that Kosovo has initiated and supported this international court. It is a small country. The proceedings here concern events over 25 years ago and are not being watched very much outside of Kosovo. But in an international landscape where states withdraw from international courts when they are being investigated, or they just don't sign up in the first place, or when they do, they fail to cooperate with the court, or even worse, they impose sanctions on the judges of courts. Kosovo's commitment to justice must be commended, and it deserves its proper place amongst the nations of the world, and nothing less than wholesale respect for the rule of law. As I have stressed, the legacy of this court for Kosovo is huge for the rule of law and for future reconciliation, even for a small country that is not at the center of the world's attention or grabbing the headlines like so many other distressing conflicts at the moment. The Serbian authorities' support for the court must also be considered, particularly in order for forensic purposes to assess the evidence that they have provided to the court. As I have stressed, it is intellectually dishonest to argue that you can disregard the Serbian policy and domination while assessing whether the KLA essentially had a similar policy going in the other direction at the same time. I mean, the plausibility of that KLA alleged policy has to be looked at in the wider context. You can't ignore what Serbia was doing as though they are ships passing in the night. This is classic doublespeak from the SPO. The evidence shows that a system of apartheid was practiced by Serbia at this time. This is a system that originated in South Africa, which was fortunately ending that system there in the early 1990s, as it was tragically going in the other direction, escalating in Kosovo. And while laudably the perpetrators apologized in South Africa and sought reconciliation, in Kosovo, the Serbian architects of the policy and those who had implemented it, they instead accused the very persons who suffered under that system and demanded that they be put on trial for their own alleged policy. Indeed, they provided the purported evidence to have it done at international courts. So they could say, well, you see, we told you, these KLA, they are thugs, they are terrorists with a big criminal plan, and we were justified in what we did in Kosovo. In essence, the repressive system of apartheid should be validated. Now, the assessment of the quality of that evidence provided in that way from the Serbian authorities must surely take into account, as it would have in South Africa, as it would have in Ukraine, surely take into account those particular origins and motivations. And our brief deals in detail with the evidence that was handed over by those authorities. We've got sections looking at the notebooks and other documents regarding their authenticity, chain of custody, and what they show. And Your Honours, this is obviously different, as the appeals chamber noted in the Intercept's appeal. The stage of admissibility, which they upheld, is one matter. This is different now to looking at whether it's been proven beyond reasonable doubt. And the appeals chamber said that it would be necessary to look very closely at the evidence provided by the Serbian authorities in relation to intercepts, but other documents as well. So Your Honours know very well that's the standard that now has to be met. It's one thing to shovel it all in, as the SPO have done. It's another thing altogether to go back and look at whether or not it's actually authenticated, taking into account where it came from. That is a basic criminal principle in relation to the admission and then the use of that evidence, if it's going to be used at all. We say it can't be. It's got to be taken out of the equation. It amounts to nothing. It hasn't been authenticated. And in any event, even if you look at it on its face, it's not corroborated by any other evidence. It just stands there as a pile arriving from Belgrade. Finally, Your Honours, I said under this heading I would touch on Your Honours' interventions. Mr. Emerson, assisted then by Mr. Andrew Strong, said in his opening speech that Your Honours will wait in vain for the evidence against Mr. Vaseli. And that frustrating wait may be what led Your Honours to step into the fray and to question witnesses. Now, it's a matter of record that the defence objected to that practice. I'm not going to repeat that here today, not because clarifying questions should not be asked by judges, but because, as we submitted, of the way in which it was done and the impression it created. We submitted it all travelled in one direction in favour of the prosecution's case. Prosecution sat back in the comfort that their case could be bolstered. There was, I remember looking across the courtroom, minimum concern on their faces, and in fact very little re-examination ever happened. I looked at the latest figures yesterday of all witnesses. The number of minutes spent by the prosecution in re-examination after the Honours questions was 18 minutes, and for just the Vaseli defence, 14 hours. Now, Your Honours, we could have a very interesting debate about the merging of the common law, adversarial and civil law inquisitorial systems for the forensic testing of evidence in court. And that will be a debate, I'm sure, that goes on before many courts in the future, but it's not one that we have to go into today. Rather focusing on where we are for Mr. Vasili in this trial, regardless of those matters, even with the evidence that arose from Your Honour's questions, the SPO did not manage to resurrect its dwindling case. You will note that the SPO have cited to Your Honour's questions extensively in their brief, at least 36 times for Mr. Vasili, just in relation to intelligence matters, and there are many more. We invite you to look closely at those cites, as none of them amount to any evidence against Mr. Vasili that supports the prosecution's case. To give just one example, Your Honours, paragraph 517, footnote 2130 of the SPO brief, they make the strident claim. They say Vasili had responsibility for and oversaw the KLA intelligence services, which were specifically tasked, in cooperation with the military police, with identifying and taking measures against opponents. This is all opponents. That's what they say, these broad, strong statements. And they footnote to questions asked by the bench of Mr. Mustafa. This is at T5905, where he was asked questions based on a statement by Mr. Humoli about who was responsible for identifying collaborators and passing on that information. And what he said was, I know that the intelligence service could never get consolidated. I don't know to whom an officer who had information would have reported with respect to the intelligence sector, because it was not functional. So when he was asked about who was responsible for doing this, that's what he said. It wasn't the intelligence sector, essentially. It wasn't functioning. Now, Mr. Humoli was one of those witnesses I mentioned earlier, who the SPO had a witness statement from. It was used in these questions, but he was never, ever called to give evidence. Now, this evidence clearly doesn't support the SPO's blanket allegation that Mr. Vasili was responsible with the military police for identifying and taking measures against all opponents. And the SPO don't cite to the mass of evidence, where they make this cite, they don't cite to the massive evidence that Mr. Vasili had no contact with intelligence persons in the zones. They came here to court to say that they never reported to him, they never received orders from him. I mean, it's selectivity of footnoting beyond the pale in our submission. So there's nothing in the evidence elicited through all of the questions which allows any case to be put against my client other than the one that the SPO have tried to put now. The accused cannot be convicted on any case that has not been put by the SPO and of which the defense have not had notice. The central point we are making, Your Honours, I think it's clear, is that regardless of all of the questions that were asked, nothing comes anywhere near proving to the high criminal standard, proof beyond reasonable doubt. And it would be hard to identify a legal maxim more essential to the international sense of justice. It provides the ultimate protection, in this case, not only to Mr. Vasili, but to the court as well. Indeed, the history of this principle reveals that it was originally concerned in medieval times with protecting judges, jurors, and the court, intending to reassure them that if they were sure to that standard, they could convict without risking their own salvation. Judging was a spiritually dangerous business then, and hence the need to get it right to the most scrupulous standard. Now here, the common law and the civil law travel hand in hand, and we don't need to even start embarking upon any of those debates. The maxim of in dubio pro, in doubt, you must decide for the defendant, which comes from the Roman canon law of continental Europe, is closely linked with the development of the reasonable doubt standard from the English common law. They appear to have had their origins in the safer path doctrine, namely, when faced with any doubts, a judge must choose the milder path, it being the path of a safe conscience, not to condemn any person while there exists even the minutest possibility of innocence. There can thus be no backlash for taking the safer path of acquittal when the doubts in our submission are palpable. That is the only rational path to be followed in Mr. Vasili's case. Those are my 4 overall points, Your Honours. I will now turn, as I foreshadowed, to look at the prosecution brief, as it was amplified in the oral submissions, in some detail, using some very practical examples to show how they haven't properly sourced the extravagant allegations that they make. And I'll do that in 3 simple parts with a few examples. I'll look at direct involvement. I said there were a few bits and pieces I was coming back to. I'll tidy those up. 2, then I'll look at JCE and the paragraphs and sites that they rely on. And then lastly, very briefly, I'll look at alternative forms of liability, including superior responsibility. Direct participation first, then, Your Honours. Any case, however big, can be boiled down to a few pieces of core evidence and arguments that a prosecution, in essence, rely on. And I suggest it's there in paragraph 515 of the SPO's brief on direct acts, which the SPO heavily rely on. Your Honours may want to turn some of these paragraphs up as I go along, but 515, one feels is the fulcrum of this case for the SPO. In just the next paragraph, 516, after they have, in 515, said this is what Mr. Vasili actually was directly involved in, they say this conduct of direct involvement was not accidental or coincidental. These examples of Vasili's personal participation are significant, not only in their intentional and manifest contribution to the common criminal purpose, but also as revealing Vasili's broader awareness and acceptance of the JCE, to which Vasili was a willing participant. So if the direct allegations collapse, which plainly they must do, then we submit the guts of the SPO's case is gone. If Mr. Vasili was not involved in anything criminal, directly so, which is clearly the case, then that plainly undermines a purely circumstantial case about being central to a JCE and having knowledge of crimes. When he's doing his tasks and moving around, meeting persons, as is shown on the evidence, for military purposes, that is all done then without any direct involvement in these acts, which he wasn't involved in, and any criminal activities. So it dramatically changes the picture. The SPO rely on these instances to say that shows his intention to contribute to the JCE, it shows his knowledge of the crimes, ultimately it shows therefore his superior responsibility as well. So if you strip that away, then he's participating in all of these activities that are relied on, like allegedly getting RPGs and things like that, without this knowledge, without this participation. So Your Honour should really look at those alleged incidents first. Paragraph 515. Decide those, we say you have to decide them in our favor. And then you put them out of your mind. Then you start looking at what's left in the circumstantial case. Starting then with 515, and I do want to go through this paragraph as one of the examples, but it's more than an example. As I say, it's an absolute central tenet in the case. They start by saying that Mr. Vasili, through the collective decision of the General Staff, appointed Jem Gashi to head the Dreadnoughts unit. So that's their first example of direct participation. Now, here we're back to this hackneyed claim of collectivity, which is plucked out of the air again. But more than that, Mr. Vasili's alleged involvement is contradicted here by the SPO's own evidence. The SPO relies on the evidence of W4748, who singled out someone from the General Staff who was responsible for this appointment, but it was not Mr. Vasili. That's at T3476 and 3479. So other than the collectivity nonsense, I mean, this allegation totally fails on the SPO's own evidence. The Honours are going to have to look at each of these footnotes just to show and double-check how that plays out. But it doesn't play favorably for the prosecution. Now, the second part of 515A is the removal of the two that I mentioned yesterday and today. Pure hearsay, uncorroborated. And then we move from there to 515B, which is the allegation of being present at the transfer and release of W3875. This is the Kletchka incident I mentioned yesterday. So I'm not going to repeat myself on those, but I do just want to add to show how stark the contrast is here between the kind of evidence that would be required to corroborate this, which just doesn't exist here. The SPO has not identified in relation to these incidents, as I said yesterday, any consistent pattern or other evidence for Mr. Vasili's allegations of direct participation. The Shala appeal in our submission is instructive on the type of evidence that could be sufficient, but which clearly does not exist in Mr. Vasili's case. So this comes from the appeals panel in Charlotte. They made findings that the accused in that case, his intent to murder a victim in the case, which had come from an untested statement, had been corroborated because there was other circumstantial evidence that could be tested that confirmed this. And they go through what this is. They said, namely, direct evidence in court of the accused's involvement in the detention and mistreatment of detainees in the same place at the same time. The accused witnessing violence inflicted on detainees by other JCE members. That he was the first to hit a particular victim, showing his authority to take initiative. And that he continued to participate in mistreatment even after detainees had lost consciousness, thus showing he already possessed the intent to kill. That's at paragraphs 847 to 851 and 502 to 505. Now, there's obviously no such corroborative evidence in respect of the two taken away or the alleged detainee in Kletchka for Mr. Vasili, that he was involved in any alleged disappearances or murder or detention. There's simply no pattern or similar such evidence, no history of being engaged in or witnessing violence at all. I mean, the factual scenarios could not be more starkly apart. That's what the appeals chamber said would be enough. I mean, we know we're even beginning to get near that. Likewise, the appeals chamber's finding on the JCE in that case showed that each element of the JCE was considered to determine if the untested hearsay was corroborated by other tested evidence, with the panel noting the live evidence of the accused's involvement in mistreatment, his physical presence in the same place as other JCE members involved in the mistreatment, acting in the same manner at the same time, and the pattern of the apprehension and detention in the same place where the accused had been present and participating in the mistreatment. That's paragraphs 502 and 505 again. So it's not only the direct participation, but for the JCE as well. They had to have live evidence showing that the elements of criminality were proven, or even if they're not criminal acts, if they're going to be relied on in some way, they've got to be proven with evidence that is properly corroborating. Now, there's zero such evidence in Mr. Vasili's case. And it is significant that the appeals panel did overturn certain findings on torture in that case against 5 alleged victims that were based purely on untested hearsay, on the grounds that the pattern or other evidence, even in that case, did not corroborate that these persons were tortured. Rule 144A was found to be violated. That's at paragraphs 512 to 551. Now, that did concern the underlying crimes, not the accused's personal involvement, but the principle is exactly the same. The pattern or other evidence must corroborate the personal involvement of the accused in the crime, if that's the allegation that's being relied upon. Even if it confirms the underlying crime separately, that does not mean that personal involvement is shown by the pattern evidence. The pattern evidence has to be trained and focused directly on whether it shows the accused's involvement, with the criteria that I mentioned earlier. And importantly for Mr. Vasili's case, the appeals panel was very clear that multiple hearsay does not mutually corroborate. In one of the torture allegations, at paragraphs 544 to 551, 3 hearsay accounts, very similar to what we've got with the 2 persons being taken away. 3 hearsay accounts were relied upon, and the panel said that the conviction based on that evidence violated Rule 144A. A 4th witness who could testify about the mistreatment generally made it no better, they found, as it did not go to the specific facts alleged in the hearsay. So I've dealt with those 2. The rest of it, the odds and ends, we have to go through because they are relied on here, even though they weren't mentioned in the oral submissions, and they're riddled with flaws. So let's look at 515B, which continues and evokes the cliched association argument again with respect to witness W4743, Mr. Nasser Krasniqi. And they introduced this to the SPO by citing Mr. Vasili's testimony in 2012 about Schick. And they say the following there. Mr. Vasili himself declared under oath that he was nominated as head of Schick at the end of March 1999, and before that, the head of G2, that one of the segments of his activity was dealing with Serb collaborators, that he knew 4743 very well, and that 4743 was a Schick member and one of the best guys coming out from the war. And he was involved, this is 4743, in the detention and mistreatment of opponents. I don't know if this is an attempt at some kind of pattern that the SBO is trying to portray, but it's a forlorn hope, we say. I mean, first of all, Mr. Vasili's testimony that they refer to is all about Schick after the war, as he describes its development in the period after the war, in the second half of 1999 and into 2000 and beyond, until its dissolution in 2008. I mean, Mr. Vasili states in terms, the capabilities of the Schick structure at the beginning were very limited in numbers and in training. Only later, perhaps the second part of the year 2000, we had started to establish the basis of the structure and function properly in terms of operations. That's P789. Indeed, Mr. Krasniqi gave this evidence that he was recruited in early 2000, the spring of 2000. And he said in his testimony that's when he received training from friendly international agencies. And that was the first training that he'd got in intelligence, namely in 2000. This is at T24770 to 74. So it's all about after the war. You're going to see this over and over again. What the SBO does is they jump to after the war because they've got nothing in the war to try and then say, oh, well, that shows what must have been happening in the war. But they've got to prove the link. I mean, it potentially could, but where Mr. Vasili is talking about Schick developing after the war, it's got nothing to do with what happened in the war. And if after the war they're looking at how they're going to now focus on security issues, ensuring that they get all information, well, that doesn't mean it was happening in the war. I mean, that's precisely the opposite. They couldn't do that in the war, and then over time they were able to develop it and build it into a proper structure much later. But that's all irrelevant to what was happening at the time. They've got to prove what was happening at the time. Second, the reference to collaborators or concerns Schick's work after the war. And there's nothing unlawful about having civilian intelligence and addressing all security risks. The SBO neglects to mention that Mr. Vasili made it absolutely clear that there was no case for taking revenge on collaborators. I mean, this was after the war. It's there in the interview, but just completely overlooked by the SBO. This is at P789, and it's dealt with in our brief in detail from paragraphs 7 to 5 onwards. And then third, for during the war, there's no evidence Mr. Krasniqi had any dealings with Mr. Vasili. So they keep referring to him as a key person that shows what was happening during the war. But there's no evidence that they dealt with each other. But for one encounter, which I'll come to, in May 1999, one very brief encounter, but nothing before that. And no evidence from anyone else that they were working together, closely together, linked in any way to the crimes that are alleged against Mr. Krasniqi. The SBO can't say, as they do in footnote 2128, that you honors, can't believe anything Mr. Krasniqi says. They called him and relied on him endlessly in respect to this one encounter. They keep coming back to this one encounter. I mean, it's just another example of the schizophrenic case theory. They say, just you can't trust anything he says. But this one encounter, that's very important. We need that. So he's telling the truth about that. Also take note, we ask you on this too, that Mr. Krasniqi, although charged by ULUX courts with mistreatment of detainees, was acquitted of all those charges. The case in which the lone witness for the Kletschke allegation, W4839, on the other hand, was shown to be a liar again. He was found to be a liar. Once again, a contrasting point not highlighted by the SPO. Now, the SPO might say, well, Your Honours, you're not bound by any of that, or any of these other previous findings. But, okay, but then where's the new breakthrough evidence that has gone beyond those trials, that shows that he should be found guilty, or that this lone witness 4839 is suddenly resurrected as a truthful man? Just doesn't exist. And if you say someone is a nice guy some 12 years after the war, how can it possibly mean that you knew them and worked with them during the war? If anything, I mean, this shows just how low the SPO has had to sink, to clutch at things much later to try and fill in the hole for what happened in the war. But this is the core of their case, here in paragraph 515. This is where they go full tilt. So you will see them, Your Honours, throwing uncontrollably, hoping for something to affix. Then lastly, Your Honours, before the break, the other bits and pieces which I mentioned, there are two other allegations made of direct involvement. But it appears now, the SPO didn't say otherwise in the oral submissions, but in their written brief, that they've really rowed back from saying that Mr. Vassili was directly involved at all. The one was an allegation that he was present in which Uk Thaçi expressed support for the KLA and knew about an alleged mistreatment. But that's not supported by the evidence, and the SPO seem no longer to be asserting Mr. Vassili's knowledge or involvement in that. There's only one reference to him in a footnote in relation to this allegation, which doesn't follow through what is there in the indictment. And we deal with that in our brief anyway, at paras 544 to 548. And two, another scrap that Mr. Vassili ordered the arrest of a person. I won't mention the name because it's protected, but we deal with it at paragraphs 556 to 560 of our brief. This was in June, apparently, 1998. But the SPO have written Mr. Vassili out of this narrative. They now just refer to it as a sort of general staff order. They don't mention him specifically in the brief. So it appears a concession has been made. They can't prove it. And in any event, there's no evidence of it, as we've set out in our brief. So you could just brush those aside. To conclude then on direct participation, the SPOs daringly proclaim in paragraph 516 that I read out to you, Honours, that these allegations of direct involvement show Mr. Vassili's intention and contribution to the JCE and reveal this broader awareness of crime and therefore a willingness to participate in it. I mean, this is a bold-faced statement that is completely unevidenced. A statement easily made, but it does not prove itself no matter how many times you shout it from the rafters. In our submission, Mr. Vassili's alleged direct participation must be struck from the indictment, including then, very importantly, how it apparently evinces his intent and knowledge and somehow an acceptance of this JCE. Your Honours must put it out of your minds as not being proven to the criminal standard when you move on to look at the rest of this purely thinly veiled circumstantial case. And if that's an appropriate time, Your Honours, I'll then come on to the examples in relation to the JCE after the break. Thank you.
Thank you, Mr. Dixon. Before we break, Judge Mitro had a clarification request.
Thank you, Judge Smith, and that's for the SPO. It's at page 28389 of Monday's submission, line 20. The proposition was made that Lahi Brahimai was also present at a meeting at the Duka Gini command which adopted rules providing for the execution of collaborators with the enemy. No reference was given. Could we get a reference after the break?
Yes, Your Honor.
All right, fine. We'll take a half-hour break at this time. We'll be back at 11 o'clock to start, or to continue with Mr. Dixon's presentation. We're adjourned until 11.
All rise. All rise.
Be seated, please. All right, Mr. Dixon, if you're ready, you may proceed.
Thank you, Your Honors.
Sorry to interrupt, but did you want a response to the
Yeah,
clarification?
yes, you can, if
sorry
you
about
have it.
that. So in relation to Judge Mitro's question, I can refer Your Honors to P1598, which are the minutes of the Duquesne Regional Staff Work Meeting on 21 June 1998. Adjudicated facts 257 to 259, which concern the same meeting and the military police regulations adopted, as well as Lahi Brahimai's attendance. And then the regulations themselves are P908 ET.1 and P927 ET.
Thank you.
I believe that's it.
Thank you. Mr. Quick? All right, now, Mr. Dixon. Amplifying. We'll step aside for a few minutes while we work on this.
All rise. All rise.
be seated. All right, Mr. Dixon, we'll try again. You may begin.
Thank you, Your Honours. I'm going to now move on, as I said, to some examples in relation to the JCE, the purely circumstantial case, with the opening submission that the SBO is truly on the last of its 9 lives when it falls back on a purely circumstantial case to support the JCE alleged against my client. It starts with a quite remarkable claim at paragraph 480 of their brief. And they put this up on the screens as well, saying that what my client had said in an interview that was published on the 9th of February 2013 was evidence of the General Staff acting in a collective way. You'll recall, Your Honours, they cited to what my client had said in an interview many years after the war. This is a media interview, not when you're under oath being asked specific questions. But he said, not that there's anything in it, we did not have separate duties, but all did whatever we could. We were engaged in leadership, logistics, intelligence, because the circumstances were such. Now, if the SBO had just gone on to the next passage in this interview, they would have seen that it is clear Mr. Vasili is talking about an early stage in the conflict, because he goes on to say, just in the next paragraph, that it was sometime in May of that year, and he's talking here about the period of 98. So May 1998, after we had talks with Agam Cheku, we began to make the KLA structures more professional. Then Cheku, not forgetting the extraordinary role of Bism Zarapi, who as Chief of Staff managed to structure the army, we began to build the specific structures of the KLA based on NATO structures, G1, G2. So he goes on to explain that, yes, in the beginning it was general, chaotic, but then we started, particularly through professional soldiers like Zarapi arriving, to try and build it up into structures. I mean, you know, that's hardly, on any view, my client saying we all acted collectively in everything that we did, and that means that you can use that to show he was involved in a JCE. I mean, the SBO has to prove that they were working together in a plan to advance a criminal campaign. I mean, my client doesn't say anything about that there. We're just talking about structuring so that there could be more organization, not collective responsibility. And in that organization, there would be different roles. And then, by definition, it doesn't mean that if you're in one area, you're going to take responsibility for everything in another area. It is beyond the pale, Your Honour, as we submit. I mean, great caution must be given to attaching weight to media interviews. This took place in 2009, years after the war, in any event, when Mr. Vasili is rising to prominence politically and answering general questions that are then recorded by a journalist. And they're not a statement recorded by him and signed. But in any event, there's nothing at all in this evidence. I mean, it's hardly the hatching of a criminal conspiracy. The SBO is only heading downwards, floor by floor, and you're now really in the basement when they try and show that this is proof of Mr. Vasili's contribution to a JCE. The acts, including this one that they say do contribute to that, are set out at paragraphs 508 to 527 of their brief. And that harks back to an earlier period in the brief on intelligence, paragraphs 255 to 273. That's really the cluster of the evidence that they present. which your honours will have to go through, obviously, and look at the footnotes on that. I'm only going to be able to give you a few examples. The paragraph I referred to earlier on direct responsibility is right in the heart of that. But then you have to look at all of these surrounding paragraphs. But rarely it amounts, your honours will see, to them repeating over and over again the same thing, in slightly different ways in the text and the footnotes. But you'll be forgiven for thinking really it is a stuck record. I mean, let's look at paragraph as an example, 508. They start by saying that one of the circumstances is that Mr. Vasily participated in general staff meetings where decisions were taken on the organization of the KLA and appointments made of commanding staff. The footnote is 2083, I referred to it earlier this morning, where they really just refer to 2 general staff meetings out of the 35 that they have led evidence on. It might be 3, but that's there's nothing in that evidence at all. There's nothing that shows Mr. Vasily was deciding on appointments of commanding staff. I mean, even if he was, I mean, that's not a crime. But then they start to imply the serious criminal intentions on his part. In the next sentence in 508, Vasily ran the apparatus responsible for identifying suspected collaborators, collecting and analyzing information about them, and maintaining contacts with intelligence units. Here we have footnotes 2086 to 2088. It comes back to Mr. Vasily's interview from May 2011, clearly referring to Schick after the war. I mean, the prosecutor is asking him questions in that interview, refers to 2000, just above the reference that the SBO give, and then he's asking about Schick's and the departments in Schick. Mr. Vasily starts talking about the different departments in Schick. And of course, at that point in 2000, they were starting to operate because we were in civilian times, and any country is allowed to have an intelligence service. That is not a crime. Mr. Vasily said the same thing in his testimony to the Supreme Court. Following this interview, then there was testimony in the Supreme Court in June 2012, the same case. Once again, all concerned events after the war. This is P789 that I referred to earlier. And it does not say anything in there about mistreating anyone. If you read it, I mean, there's no stretch of the imagination that would allow such an inference to be drawn. It talks about what intelligence services do. They work with persons and agents close to the other side. Nothing criminal about that. A number of 200 persons that they're working with is identified. I mean, this is precisely the training that Mr. Vasily would have received abroad. And we see it put into practice here after the war in civilian intelligence. There's nothing in that about maintaining contacts with intelligence units during the war. He doesn't say, yes, during the war, this is the way we were doing it. Because they weren't. It just didn't happen. It wasn't able to happen. It happened later, after the war. There's also reference to a documentary covering Mr. Vasily coming to The Hague in 2019 for his case C interview. That's P4212, which once again has absolutely nothing in it about collaborators. I mean, it's a bit of public posturing, coming to The Hague. I mean, it's really stretching it to say this is evidence of Mr. Vasily running the entire apparatus of identifying collaborators throughout the war. The SBO tried to suggest that Schick was really all up and running from April 1999 with Mr. Vasily as its head, even though they also say that because of UNMIK, the provisional government was not allowed to do anything. I mean, once again, this is all based on Mr. Vasily's interviews, which just simply do not show that anything was actually happening in April, May, June, July, August of 1999. And there's no evidence brought by the SPO that shows that SHIC was operating then. We don't have to show what was going on, they do. But on what they point to, it all shows in a general way that it wasn't until much later, after the war, the latter part of 1999, that things began to happen. And that accords with the evidence about the very intense and scrambling months of the NATO bombing from late March 1999 up until the end of the war in June 1999, which was naturally the focus of attention. I mean, it's hardly going to be the time that you are embedding your civilian structures when you're focusing on extensive bombing. It was an overwhelming period of time as thousands fled, refugees going in all directions. The Serbian forces went all out in a final attempt, making it extremely difficult and dangerous to be organizing and moving around. It also accords with the evidence of the very important demilitarization process that followed, in which Mr. Vasily participated, as we have seen, which was a further focus of attention. The provisional government only started becoming active after the war, and then in limited ways because of UNMIK. As you heard from many of the international witnesses, it was more for show than anything else. And some of them even said, well, they shouldn't have been doing anything. As far as I know, they weren't doing anything. The SPO relies heavily on the appointing of persons later after the war in SHIC who had been involved before in the war in some way. But that does not show any command over them from the time of the war or knowledge of what they were doing then. The SPO has to prove knowledge at the time. Otherwise, anyone who appoints someone later must be deemed to have known them from before the war. I mean, that must be wrong. It begs the question. You have to show that you knew each other at the time, not later. Or even if you didn't know each other then, you knew about what they were doing then, not what you did later. It was only after the war, as I've stressed, that a civilian intelligence structure, as we've seen on the evidence, the limited amount that there is, emerged in reality. It was only then that Mr. Vasily was able to and begin to build and then lead such a structure. The evidence shows that during the war, it was impossible to, in reality, get it off the ground. The contact and training abroad during the war certainly assisted for what came later. As the SPO acknowledges, after Rambouillet, Mr. Vasily left his position as head of G2 military intelligence in the KLA, and that was at the beginning of April 1999 that he became head of the civilian intelligence with the formation of the provisional government, with SHIC being a department in that government. So they acknowledge that. However, what they don't acknowledge is how events then, at that time in April, overtook that entire situation. You had the NATO intervention and the escalation of that over time, particularly as the Serbian forces made greater and greater attempts to resist that, followed by the capitulation and surrender of the Serbian forces, and then the introduction of UNMIK, demilitarization, various joint structures. You've heard the evidence of that. I mean, it was only after the war that there was any breathing space to look ahead and to start establishing proper structures. Ignoring all of that evidence, however, the SPO take the huge leap in the rest of paragraph, we're still on paragraph 508, of saying from early on, intelligence was essential for the KLA's abilities to carry out operations, including against opponents. So they put intelligence at the heart of it. And my client, as a result, doesn't matter if it was an intelligence unit somewhere in a village, they say, if it's there in the village, it's Mr. Vasily. And there's a single footnote to support this, as that's at 2089. And it's the same old media interview again of Mr. Vaseli in 2009, and the same quote that I gave above. Apparently, it covers both collectivity now, but also it shows that operations were launched by intelligence against opponents, as alleged in the indictment. But your honours will note not a single reference, if you go through that interview, not a single reference in that interview to opponents. I mean, it's a complete red herring. I mean, the SPO cites another part of the interview, but that talks about targets for NATO strikes. I mean, that obviously can't be targeting opponents. And then there's this part that's referred to. Officially, SHIC was founded at the time of the provisional government. Officially. They don't highlight that word. Yes, officially it was done, but did it actually do anything is the question. We should know, we should know that in all the circumstances we have operated, we needed intelligence, because through intelligence we could carry out our operations and also build our defense. So they seize on that, a general statement about the need for intelligence, to say, well, therefore, throughout the indictment period, and we're not looking now at when SHIC was established, but throughout the indictment period, you must have been coordinating all intelligence. I mean, all that's being said there is that, as happens in any country, intelligence is needed to ensure defense. I mean, to leap to therefore that operations were planned against opponents is overreach in the extreme. So first we have guilt by association that I've dealt with. Now we have guilt by intelligence. Nothing unlawful about doing intelligence work. Every intelligence agency in the world, FBI, MI5, sets out through their policy and regulations that it is imperative to gather information on threats to nations. That's just paragraph 508, Your Honours. I mean, you'll see every line that follows, and I'm not going to be able to go through it, has the same reoccurring problems. I've got another example here to show the true bleakness of it, and that's paragraph 510. And I do have some slides just on this paragraph, and only 8 of them, to try and liven it up, but also to make the very graphic point that when you look at these paragraphs and go through them footnote by footnote, this is really the exercise practically that has to be done. And I think the slides do show that. And I have to say, thanks to the incredible work of my team, we have about 500 of these slides which show the paragraph then with the footnotes underneath, breaking them down as to why they don't actually support what's in the text. But we're not going to go through all of those. I'm only going to use this one. This is a core one, the crux of both the JCE, that the KLA structures, including intelligence with a vehicle, that they were some other channel for the JCE, and it's also key for the command case. So this is what they say at 510. As head of the intelligence directive, Vasili effectively oversaw all intelligence matters in the KLA, in line with the KAL regulations, which made him responsible, this is the criminal aspect, for organizing and directing the work of those subordinate units. They're going to try and scoop up everyone now throughout the country. He assigned tasks and he received reports from the zone intelligence units. So that's the allegation. Let's look then at what that is based on. Slide 2, please. This is the first footnote. 2099. They say here that Kudraku said in a media interviews again, in April 2023, that Vasili was his boss. So he confirmed that that media interview was accurate. I mean, at least they put the actual interview to him. This is his examination in chief. He said, okay, yes, Vasili was my boss. But the SBO completely ignores what Kudraku said in his evidence, that he never received any orders from Mr. Vasili or reported to him. That's T22709 to 10 and 22715 to 16. I mean, surely those are the key factors that prove oversight. I mean, not him saying in an interview, he's my boss, there's an interview many years later, that's confirmed. I mean, it's just like, okay, let's just grab the easiest thing, pluck it out of the air and use it. But what about his actual evidence, which is that when it came to has oversight been proven, he said, no, I never got an order from him. And this is the classic example of the SPO honing in on a slice, just the examination in chief and ignoring all of the cross-examination and Your Honour's questions. If we go then to slide 2, this is the next, sorry, 3. Slide 3, this is the next number they cite. Now, I mean, this is the cover page of that interview I've been talking about. It's been recycled over and over again. I mean, they can't mean that cover page supports their claim, but they might be referring to the whole interview again. So give him the benefit of the doubt on that. You know, looking through the interview, there's nothing in it that shows oversight of all intelligence matters in the KLA. It does refer to constant trainings in August and September 1998, but without any detail at all, and who knows about the dates of that, doesn't mention at all oversight of intelligence matters. In addition, if these dates are right, this was the time of the Serbian offensives, and importantly, when Zarapi was asked about this, when he was asked about this training, he could not confirm it. And he said, you have to bear in mind, Mr. Veseli was abroad, dealing with matters abroad and dealing with the FARC agreement. That's what Zarapi said in September and October 1998. SBO, once again, completely omits that. I mean, it's vital that the totality of the evidence is considered. That's omitted on a colossal scale by the SPO. And they're always very keen to say, Your Honours need to look at all of the evidence. At the end of the case, when we've got all of the evidence, you could look at it all, and it'll all corroborate. How many times have I heard them say you need to look at all of the evidence? That's the only way you could operate in a case like this. But then when it actually comes to having to justify such a serious claim, they don't look at all the evidence. They look at a very narrow selection of it, deliberately so. Because if they did, it would completely undermine their claim. Slide number 4. Now, these are the regulations. This is another reoccurring theme. A bit of media interviews, a bit of what Mr. Veseli said in interviews many years later about Schick, then a bit of the regulations. They sprinkle all the stuff together. This one, P83, the internal regulations of the KLA General Staff. Mr. Zarapi testified about this. Once again, their star witness, they don't come back and cite him here. He said in his evidence, when he was asked by the bench, in fact, about whether intelligence and the directorate in practice organized and directed the work of subordinate units and observed and monitored combat activity. That's the part that's underlined there, Your Honours. Your Honours asked specifically about that, and he said, in fact, this was very difficult in practice because its director was not present there for a longer period. And that is why we could not implement this part. I mean, it echoes the response that the bench got from Mr. Mustafa that I mentioned earlier. And then he went on to say this was a translation from model documents from Western armies. This is at T18443. I mean, a cut and paste, Your Honours, does not prove that it was actually happening in practice, as Mr. Zarapi explained. And he confirmed that these were aspirational documents for future developments, T1849425. And the SPO seemed in part on Tuesday to accept this for the first time, on Monday, in fact, when Mr. Quick did seem to say there was an aspirational aspect to this. Next slide, please, number 5. This is another regulation that they cite to. I think the part that is underlined is probably the key part that they're wanting to draw our attention to. These are the provisional regulations of reconnaissance and sub-detachments in combat. Mr. Zairapi testified that he'd never seen these regulations before. This is a T18486. I mean, no one has explained where these came from, who prepared them, were they disseminated? In the zones, people said they didn't have these regulations. Were they ever implemented? I mean, did Mr. Vasili had anything to do with this? And you can't just say, well, he must have, because he was the head of intelligence. I mean, that is kindergarten prosecution. You have to be able to show that these regulations are linked to him in some meaningful way. Certainly if you want to rely on it to prove that this shows that he was in charge of all intelligence units and overseeing a policy of targeting all opponents in Kosovo. Can't just throw it in there and say, well, that shows, because it says intelligence and no more. But, Your Honours, even if you read the regulations, I mean, there's nothing in here, particularly because they're cut and paste from Western armies, that is criminal. That somehow this means that whoever did this was trying to use these regulations to inspire people to go out and commit crimes. It just doesn't even get off first base. And then slide 6. And remember, Your Honours, the claim here is that Mr. Vasili is responsible for organizing and directing the work of all intelligence units. So they say that's because there's evidence that he assigned tasks and received reports. Slide 6 is the first one, assigned tasks. And here they rely on part of the cross-examination of Mr. Kudraku. It's the single request that I referred to a while back. You'll see there the date is 1 April in the third line. That's 1 April 1999. And he said it was chaos. During the night, 4,000 soldiers would enter the area of Klečka and Divjak. And amidst that chaos, I did meet Mr. Vasili. So that's how he comes across him, pure chance. And this is where the prosecution say, you can safely find that he assigned tasks. Well, he made a request. This is what Kudraku said. So he proposed that I went and visited them to see whether everything was in order. And I carried out that task from evening until the morning, and in my opinion, successfully. But when he came back, Mr. Vasili wasn't there. He didn't report to him. He didn't say, I've done this successfully. You need to know it's all happened. I mean, hardly the context of an order. Bumping into him, saying, can you do this? He does it. That's the only example they cite in the footnotes. I mean, it doesn't extend beyond this one request for assigning tasks to prove, the prosecution said, beyond reasonable doubt, that very strong claim. And as I've noted before, Mr. Kudraku said he did not get orders. So once again, that's not cited here. He did not get orders from Mr. Vasili, and he did not report to him. There was no parallel reporting. And that's the same for all the zones. Slide 7. This is now on receiving reports, and the SBO cite to quite a long passage, you'll see there. So we've just summarized it. This is a summary of the evidence in chief, only the evidence in chief that is cited to. And you've got here what Nasser Krasniqi said about an undetermined date in May. This is the encounter, Your Honour, as I said I'd come back to we had this short conversation, and we informed Mr. Vasili in general terms about the so-called Crimea case. This was one in which 5 military policemen were accused of arbitrary arrest and mistreatment of civilians and isolation of persons in April, so a month earlier. Even in the part that is referred to, Mr. Krasniqi makes it very clear that he never discussed any similar matter with Mr. Vasili. That this was the only one where he encountered him and he asked him about this case, and he gave him some general information about it, and then he was gone. They do not, however, cite to the cross-examination here. They once again slice it very neatly out of the total picture. Because in the cross-examination, Mr. Krasniqi made it very clear that he had got no orders ever from Mr. Vasili, and they'd never dealt with any cases before. He said Mr. Vasili was not involved in any investigations in the Crimea case and any of the decisions regarding this case. That's at T24771. The discussion about the case was of a general nature. Mr. Vasili was not involved in the investigation of any other cases or any decisions regarding cases. He was not involved in the decisions to detain any persons at Klečka or release them. And this was the only discussion he had with Mr. Vasili. He'd never had any similar discussions. He used the word anything formal or anything previously. So no reporting. He'd never received any orders and no reporting to him. And yet that is cited as evidence of receiving reports from intelligence units. This one example of this brief encounter regarding a case that Mr. Vasili was not even involved in and received only general information about. I mean, it's a complete one-off. I mean, in what world is this evidence of receiving reports from all the zones? It's not even about intelligence. It's not reporting in any sense. And the witness said as much in cross-examination. So how can the SPO with a straight face make that submission? Well, with the face about to collapse now, in order to try and prop it up, if we can go to the next slide, they go to witness 4747. And I've just summarized this evidence in very general terms because obviously citing one example to make the broadest of allegations. Now, the SPO might well say, when they reply on Wednesday, well, these are just examples, Your Honor. We're not going to cite everything there. Well, I mean, are these the best examples that they've got? I mean, surely you'd cite the best ones. I mean, is that as good as it gets? And even if there's something else, well, what do they have in mind? I mean, is it P500? We've heard about that exhibit where Mr. Kudraku was once again called to give evidence about P500. And he said he sent this to his zone commander, not to the general staff or Mr. Vasili. And he said very clearly in his evidence he did not know if it was ever sent and received at the general staff. He always reported through his zone command. And there's no evidence to the contrary. This is at T2271425 and 22722-28. Zarapi also testified that P500 never got to the general staff. The slide can come off now because it doesn't concern P500. So he said it never got there. And that's T18253. And even if you honest don't believe any of that, you say, oh, well, you know, they're trying to cover up or whatever. Well, still, the provenance of those documents hasn't been proven. It hasn't been shown that those documents ever arrived at the general staff. That Mr. Vasili knew anything about them, that there was any parallel reporting. And you can't safely find that because a witness might have come and not told the truth about it, that therefore the opposite of what they say has been proven. Because they're lying, therefore, no. It must be the exact opposite. You can't do that. You can find you can't rely on them. We say you can. But if you find you can't rely on them, you can't then jump to the other conclusion which says, well, then the prosecution has proved their case because they proved them to be liars. You have to show on the evidence that it is proven. There has to be other evidence then that the prosecution brings. But they have relied on these witnesses you've seen. Kudraku, they've relied on to say, my client was in charge of all intelligence units. So why suddenly, on this part, might he not be telling the truth? Just because it doesn't suit their case? I mean, it's that doublespeak that has to be rejected. Thereafter, they could try and say, okay, if P500 is out, you know, what about P709? Mr. Tiga referred to that in his speech. I touched on it as well. This is the Chief Lully reference in P709. And also, there's another similar document, P186, without that handwritten reference of Chief Lully on it from a day before, 18 August, where 709 was 19 August. A issue that was explored in evidence but never clarified. The prosecution have never clarified what is their case on that. Now, Your Honours have Mr. Kudraku's testimony on that he had never seen P709 before, that he had sent P1862, that's the one without the Chief Lully written bit on it, to his zone command. Once again, no parallel reporting. And there's no reason to dispute that. The SPO have the burden to prove it. They have not disproved, beyond reasonable doubt, that that's not true. And most importantly, whatever view you take of Mr. Kudraku's evidence, the SPO have not established to the criminal standard that P709 is authentic, that it is what it says it is, that it's true, that it was sent and received as well, and by who, or that it had anything to do with Mr. Vasili, that he ever received it or did anything with it in connection with it. I mean, for all we know, if it was real, if it was sent to him, he might have gotten and said, oh, this is a mistake. This is not me. I'm not G2 intelligence. Send it to somebody else. We just don't know because it hasn't been explored. It's not for us to have to prove anything. They have to go through each and every possible inference and exclude those that are consistent with innocence. They haven't done that. In any event, the SPO have not proven that it shows that Mr. Vasili, as head of SHIK in August 1999, could deal with any issues of transfers between zones in the KLA to the extent that it was still operating at that point. There's absolutely no other evidence of this that supports that contention. I mean, this is the sole document they might be relying upon to try and show that. Where it gets them, unknown. But there's nothing else which in any way confirms or supports that. It's a single hearsay document that no witness has been called to deal with and authenticate. It is uncorroborated, as I mentioned before. Findings of guilt cannot be based on such untested hearsay. The fact that I could ask Mr. Kudraku about the document does not cure the problem. I mean, his evidence, in fact, undercuts entirely the SPO case, whatever that is. It doesn't confirm the truth of its contents, whatever that truth might be. But it doesn't cure the problem that I can't cross-examine the person who is meant to have been involved in this, meant to have written that, whatever that was referring to. And there's no other evidence that supports it. So, how is it proved? It simply isn't. Thus, both of the documents that I've mentioned now that the SPO might say, okay, well, you know, the ones we showed there on the slides, they're just examples. Well, I mean, they could have added these in, potentially. They don't get them anywhere, and they know others. I mean, it's a sorry pattern that continues throughout, including in the same paragraph, where we get another distorted example. We're still in paragraph 510 now, another distorted example where they say here, he cultivated and protected the secrecy that allowed intelligence operations against opponents to function, even as public messaging was moderating to avoid external scrutiny. Footnote 2103 is the source for this. Once again, all from Mr. Vasili's testimony in 2011 and 2012 when he was asked about SHIK after the war. Nothing to do with what was happening in the war. And the testimony says nothing at all about secrecy in relation to operations against opponents in any event, during the war or after. And it's a gross misrepresentation of this. Mr. Vasili discussed SHIK slowly growing up from July 1999, after the war, into 2000 and beyond. He spoke about archiving in SHIK when SHIK was formed, and how they were assisted by intelligence services from developed countries. These are all the topics that are looked at, and it's clearly all after the war, not dealing with operations against opponents. And he looked as well at how SHIK members had to take a vow of secrecy and being prevented from disclosing any information, which, as he explicitly explains, not referred to again, he says, well, this is expected in any intelligence organization anywhere in the world. I mean, it's secrecy because intelligence services ensure that people who work with them don't go around telling everyone what they're doing. There's nothing more than that. I mean, the same pattern of recycled single incidents I've mentioned, with a dollop of the media interviews, you sprinkle a bit of unsupported 4747 on top of that, maybe a few pages from a book, and you blow it all way out of proportion. I mean, it just continues throughout, repeated in all of the sections. And citing poor evidence over and over again does not make it better. Yes, as a prosecutor, if you've got good evidence, you keep repeating it to the triers of fact. It has an impact, but this has exactly the opposite. It doesn't get any better. It shows the whole in their case. Your Honours, what I wanted to do now was to go into one or two other examples. I'm nearly finished with my submissions, and I wonder, just as we've been going for an hour, I will certainly finish by 1 o'clock, whether we could have a break, if I'm in Your Honour's hands, until 12:15, and then I'll finish the last 45 minutes, so that we just
We can do that.
break up the segments a bit.
Yeah, we can do that. Thank you. We will break for 15 minutes, then we'll be back at 1:15 or 12:15 to finish up Mr. Dixon's
Yes.
presentation.
I'm grateful for that, Your Honours.
All rise. All rise.
Be seated, please. Yes, sir.
Mr. President, I rise just to put on the record that the defense disputes that the citations that were provided to Judge Mitro support the proposition that was made, and I won't make any further submissions, but, okay, thank you.
All right, Mr. Dixon.
Thank you, Your Honours. I do want to give one further example now, because it concerns the communiques, which I know Your Honours will have in mind, and which the SPO has put a lot of emphasis on. And that's at paragraphs 520 and 521 of their brief, where they make the claim, and I remember when I first read it, I just wrote the words "wow" down in the column next to the paragraph, that my client facilitated the dissemination of KLA statements that formed the backbone of the collaborator policy. He provided the backbone for all of the communiques and statements. And they go on to say that in 521, he provided the information that then got in to those communiques. So it all comes from him, when there's not an iota of evidence of that. I mean, they do need to try and link Mr. Vasili to the communiques in some way, because it's the only way of showing any connection to the crimes. But I mean, this is truly desperate, and it can't be founded. Even the language, the way that they state it, shows that. They say Mr. Vasili received, assessed, and forwarded intelligence and informed communiques to give them practical currency. I mean, they're not identifying like what intelligence are we talking about, who did he provide it to, but they're not going so far as to say he participated in drafting and finalizing, disseminating them, following them up. I mean, that is absolutely key. I mean, if you're going to make this allegation, you've got to have some evidence that he was involved in this in some way. You can't just throw it out there irresponsibly. I mean, they don't actually allege that he drafted it, because there's no evidence of that. There's also no evidence that he was involved in this in any way whatsoever. I mean, it's guilt by association dressed up in a different way now, saying essentially you in the general staff, you in the intelligence position, involved in intelligence, and that must therefore mean that anything that discusses intelligence in the communiques is your responsibility. I mean, it's nothing more than that. I mean, it's prosecution by numbers. 1, 2, 3, tick. Do you think we have a case? Absolutely not. The footnotes that are cited for this dissemination allegation are 11 parts, first of all, of Mr. Nuri Batichi's book. This is P1264. And if you go to the passages that they refer to, I mean, none of them pertain to a collaborator policy or collaborators in any way, certainly not linking to Mr. Vasili at all. Then they go to that Mr. Vasili and others visited the Kosovo Free Press on the 12th of May 1999. There's just this one meeting that they cite to, P51554. That's it. I mean, you know, even the most zealous of fact finders could not conclude that this amounts to facilitation of statements on collaborators. Even Cardinal Richelieu could not find a reason to convict on this line alone. You go to one meeting and then you're responsible for all communiques. And then there's a final one, P515, the translation is at 59, and that is in relation to a Radio Free Kosovo report, May to June 1999. It's an archived report, no mention of Mr. Vasili at all, if you check the reference provided there. Then, you know, with regard to regular communications with General Staff members, including Mr. Thaçi, Mr. Vasili received, assessed, and forwarded intelligence. This is what I referred to earlier. That formed then the backbone of these communiques. I mean, none of the citations provided to support this are made out. I mean, the citations to his relationship with Mr. Thaçi discloses nothing nefarious at all. I mean, they're allowed to have known each other and work together after the war. I mean, otherwise we'd all be in trouble criminally. The claim that Mr. Vasili fed into General Staff communiques and declarations is critical for the SPO because there's virtually no evidence of any contemporaneous statements by Mr. Vasili. Yes, things much later, but nothing from the time. So they've got to try and weave him into this, however they can. And yet the SPO cite only 3 pieces of evidence to support it. And this is all pertaining to a single communique, none of which discloses any link to Mr. Vasili. They cite, and this is in the footnotes to paragraph 5212, communique 80, that's P1752, which was issued in June of 1999 when Mr. Vasili was not in G2 any longer. And the document refers to information received by the Drenica Operative Zone Intelligence. That's all it says. Zone intelligence. Pertaining to an attack on perceived collaborators. There's no evidence at all that Mr. Vasili had anything to do with this communique. He was no longer part of G2 then. The fact that it was issued and mentions zone intelligence cannot prove beyond reasonable doubt that Mr. Vasili has anything to do with it. So, of course, the SPO are aware they've got to go a little bit further. And they cite then to 2 witness statements of witness 4324. And this is P2868 and 2869. This is in footnote 2150, in which that witness identifies those who perpetrated this attack, referred to in the communique. And he names one of the assailants as Sabit Getsi. Now, this is not the JCE, Sabit Getsi, but a relative of his. That's made very clear in the witness statements that the SPO have cited to. The SPO had, in fact, foreshadowed this in their cross-examination of a witness, an international witness who came here at T27137. When they asked this witness about this communique, you may recall it, Your Honor, and it was Mr. Halling then that listed, saying, for those in the courtroom, he has a whole lot of evidence, and he listed a whole lot of P numbers, including these. And I remember, what's going on here? Why is he doing that? Well, now I understand it, because he's trying to say that we have a Sabbat Getzi here. Yes, not the Sabbat Getzi in the JCE, but one of his relatives. So even though they can't show the JCE Getzi is linked to my client, they're now trying to say one of his relatives was involved in this, and somehow Mr. Vaseli is linked that way. But we're even further removed now from the person who's charged in the JCE. I mean, has the second Getzi now somehow become a tool as well, but without showing any link at all? I mean, it's jaw-dropping. And let's not forget that this is all being used to prove that Mr. Vaseli was the backbone of the communiques and their dissemination. And all I can say is wow again. A final example, as it is so mind-bending and once again illustrative of the problem, is paragraph 523, where it is alleged that Mr. Vaseli coordinated with Muz Shashari, the commander of the Pastrik zone, who was involved in crimes, and coordinated with other JCE tools like Brahimai, Nimai, Getzi. So it's the association theme again. Now, this is the first time that they've actually highlighted that Mr. Vaseli was somehow linked to Mr. Shashari here. They're putting their case in this way, but they've never ever explained that before. I mean, it's a very late addition, but it's one that still doesn't get them anywhere. When you look at the evidence that the SPO claims support all of this, I mean, it's hearsay gibberish. They talk about this at footnote 2157. And the only line that they used to say that my client coordinated with Mr. Jashari, who was involved in crimes and therefore is guilty of all of his crimes, is a 2001 interview, and that's at P00413, where when he's asked about how the zone was created, he says that he worked with, and he mentions a number of people. In a general way, he mentions Mr. Vaseli, and he said that he met him previously as well. I mean, a general reference to him, no discussion about the actual formation of the zone, what they were doing, how they could possibly be involved in any crimes together. And most importantly, he was never called to testify. I mean, if he is such an important person in establishing the JCE, why wasn't he called to testify? I mean, it's again a sole untested piece of hearsay evidence which has not been corroborated. No one else has talked about this. I mean, it wasn't even admitted for this purpose, if you go back and look at when it was admitted at T8347. But it's now suddenly being relied on for a host of points because the SPO realizes they need to throw all of these strings of mud. It's now cited 13 times for this kind of proposition. The SPO has not cited to any support for the interview, not that it even amounts to anything. Possibly except P1281. They do cite that. It's a wedding video. Your Honours will recall seeing it, showing Mr. Vaseli sitting next to, but not talking to Mr. Muz Jashari. And that's cited at para 788. So if you sit next to someone at a wedding who refers to an interview much later in a general way, you are then responsible for all the crimes that it's alleged he committed. I mean, this is a dire strait of SPO reasoning. I mean, there are now no more floors below the basement to descend to. The same is true of the other links to the JCE members that are named there. You check the footnotes. None of them allow for any inference to be drawn that he was working with them in a criminal way and that he's responsible, therefore, for all of their crimes, even if he saw them occasionally here or there during the war. Your Honours, to conclude on the JCE examples, the SPO in our submission is dragging us into a Lord of the Flies type of chaos, where the rules of criminal responsibility simply go out the window. Any association will do, stretching inferences beyond recognition, and as a result, plainly failing to show that the inferences the SBO seek to draw are the only ones that are consistent with guilt to meet the very high criminal standard. There are clearly countless reasonable inferences that can be drawn that are consistent with innocence. There's no proof of guilt through this purely thinly veiled circumstantial case. It must be rejected. The last section, a short one, that I'm going to deal with is other forms of liability, both looking at the position we take and some examples. As we've set out in our final brief, superior responsibility does not even get off the ground. The effective control high threshold is the only gateway through which this could possibly happen. Without any JCE, as we've shown, without any command structure for intelligence, that gateway remains completely shut for the SBO. We see here in this section, in the brief, a new level of just tarring everyone with the same brush. The allegations are not even individualized. If you go through it, Your Honours, you'll see that Mr. Vaselli is not actually mentioned once by name. It is just everyone together is responsible. And it clearly doesn't meet the requirement to set out how the very narrow elements of superior responsibility and aiding and abetting have been met. On countless occasions, when just the word accused is used, it's used generically, you check the footnotes, no reference at all to Mr. Vaselli. It's very prominent in this section, but it reoccurs throughout the brief as well. Just one further authority that I wanted to highlight here, the Tokyo trial, going back to the Second World War, a very important bit of dicta, we say, even though it came from a long time ago. But if Your Honours had in mind, well, I mean, really, shouldn't people be leaving an organization if they find out something about it, even if that's shown, should they resign? Well, the Tokyo trial said very clearly that it was not necessary to resign if working in a department, even if you had knowledge of prisoners being ill-treated. I'm not saying that that's the case here at all. It hasn't been shown. But they were looking at that scenario there according to that factual case. The prosecution, this is the judges from the Tokyo trial said, the prosecution has to show that their functions included the administration of the system to protect prisoners, and that they had knowledge, or should have had knowledge, of crimes, and did nothing effective to prevent that within the powers within that system. And that's at pages 31 to 32 of the judgment of the International Military Tribunal for the Far East. So it shows how tightly knit those narrow requirements are, and how they have to be established. So we're not talking about general negligence liability, but individual criminal responsibility. You actually have to show that you're in the system that is there to administer prisoners, irrespective of that being an international armed conflict or an internal one, and that within that system you had knowledge and were able to take steps within your powers to prevent such crimes. There's no evidence of any such system, structure that Mr. Vaselli was involved in. It wasn't there for the JCE. It doesn't suddenly appear for superior responsibility. There's also just one other legal point to highlight, and that's JCE 3 at paragraph 605 of the SBO brief. The SBO say the accused, this is their heading, strove to take control of Kosovo despite knowing that achieving this goal may result in the commission of crimes charged. It seems to have been stated rather broadly. It might not be exactly what they're intending, but it is very important to emphasize that for JCE 3, you have to have entered into JCE 1. You need to show that there is a common purpose to commit a crime as the first step. That common purpose must exist. It can't just be a case that all crimes were merely foreseeable. You have to get through the hurdle first of showing that you were involved in a common purpose to commit particular crimes, which, as I've shown, hasn't been done for Mr. Veseli. And then thereafter, there could be foreseeability. But it can't all be generally foreseeable or generally you heard about things. Some of the crimes must have been intended, and you have to be linked to that intention through your own participation and actions. We've set this out in our brief at paragraphs 650 to 653. So if the SBO tries to start arguing that, well, just foreseeability is generally enough, that's wrong as a matter of law. Your Honours, in conclusion, we had to wait until Mr. Laws's submissions on Tuesday for the voice of reason, through a recognition that a war of liberation can be fought with the overwhelming number of the KLA members doing so in perfectly good faith, and that some crimes can also be committed, which, as he stressed, must be acknowledged and for which there unquestionably must be justice. The 155 victims in this case, and others, who suffered deserve nothing less than their peace and justice. Our common humanity desires that, as we would want for us and our families if we had been harmed in the same way. However, it is a fool's errand for the SBO to pursue persons like Mr. Veseli, vainly hoping that that will bring closure. I mean, we can see the SBO's thought bubble in this case, that we can't bring this JCE without an intelligence component, particularly as some of those who committed crimes on the ground claim to be intelligence or secret police or secret whatever, some similar formulation. How could intelligence at the General Staff be left out? They must have been thinking. I mean, it's a classic, let's find guilt in any 6 lines of an honest man. In doing so, the SBO cast aside the legitimate work undertaken by Mr. Veseli in the KLA. They've overlooked the example he set throughout the war to promote the KLA abroad, and then, supported by the international community, unite the people of Kosovo and to achieve a peace deal, which has been resoundingly praised as one of the most successful transitions to peace and an admirable example of a national and international partnership achieving in unison an enduring outcome. That is a most laudable platform to achieve justice, far advanced than most of the conflict-ridden regions of the world today. Justice is the constant that allots to every person, to every victim, their due. The victims deserve their due, as does Mr. Thaçi deserve his due. Deserve what is proper and fair. He must be acquitted on all charges To do otherwise would be a grave injustice. Thank you, Your Honours.
Thank you, Mr. Dixon. I think we'll just break for lunch so that you can start fresh at 2:30 and as planned
Thank you, Your
with
Honour.
the Salimi defense. And so we will be adjourned until 2:30.
All rise. All rise.
Be seated, please. All right, we're ready for the Salimi defense final statements. Mr. Roberts, you have the floor.
Thank you, Your Honours, and good afternoon to you and to everyone else in and around the courtroom. It's my honour and privilege to commence the final submissions on behalf of my client, Mr. Salimi, almost 3 years after I presented opening statements in April 2023. Since that date, Mr. Salimi has sat patiently and respectfully throughout this trial, attending every hearing, either in person or remotely, and you'll hear from Mr. Salimi next week. Mr. Salimi is wholly innocent of each and every crime in the indictment. As the defence has demonstrated at length in its 380-page final trial brief, the SPO has simply failed to meet its burden to prove any of these alleged crimes beyond reasonable doubt. That's it. That's our case in a nutshell. The defence bears no burden to disprove the prosecution's allegations. By simply making allegations against Mr. Salimi, the SPO cannot shift that responsibility onto the defence. It has to produce relevant, consistent and probative evidence and reliable witness testimony to prove these allegations beyond reasonable doubt. On every single front throughout this trial, it has failed to do so. Now, I will share the time allotted to the Salimi defence with Mr. Tully, to my right, Mr. Mayor, and Ms. Sheremetti. I expect to speak for the rest of this afternoon, about 2 hours, before my colleagues take over tomorrow morning, and then I will come back at the end briefly to sum up. Throughout these submissions, we'll seek to reply both to the SPO final brief, the written brief, its oral submissions, and also to elucidate some parts of our own final brief. But unlike the prosecution, and I will say this very clearly, we have nothing to hide as to the content and nature of our case. Through these submissions, we intend to be as open, as transparent as we can be. We will not hide behind meaningless and ambiguous phrases which permeate the entire final brief of the prosecution. We will address the evidence that's been tendered in this case, and we will examine what it actually proves rather than what the prosecution wishes it proved. We will do so openly to assist your honours in adjudicating the various allegations against Mr. Salimi. Now, your honours have already benefited from extensive submissions from counsel for Mr. Thaçi and from Mr. Vaselli. And we adopt and endorse those submissions to the extent they're relevant for Mr. Salimi and do not intend to repeat or reiterate them. We also stand fully by our written, factual and legal submissions in the final brief, but also across the entire 3-year trial. In particular, on a substantive level, the legal challenge to the existence, nature and scope of JCE liability, as well as the direct challenge in our brief to JCE3 for special intent crimes. Today, I'm going to address JCE in all its aspects against Mr. Salimi and divide it into 3 separate aspects. So first is the JCE as a whole, its nature, its members, and its objective. Secondly is Mr. Salimi's alleged contribution to that JCE, both direct and structural, including those allegations where he's allegedly has personally participated in incidents or crimes. And finally, Mr. Salimi's alleged intent. But before I enter into those substantive issues, I just want to address one procedural question. And that's a central question that does affect a significant amount of the prosecution final brief and final arguments, and that's the reliance on Mr. Salimi's SPO interview and other interviews that he's given before Kosovo courts, before the ICTY, or also to the media. Now, obviously you heard from counsel for Mr. Thaçi the number of times that they estimated his interview was relied on by the prosecution. We consider that it was relied on 326 times in the SPO brief, and in many of those times it is the sole source relied upon by the prosecution, including in material facts against Mr. Salimi and supposedly against his co-accused. I will not detail all of these specific references, but there are extensive numbers throughout the brief. Now, as clearly set out by the appeals panel, these statements, interviews and transcripts of Mr. Salimi cannot be attributed significant weight without corroboration to determine an allegation beyond reasonable doubt. This is a crucial consideration for the trial panel when assessing the evidence in front of them. Now, no defence witnesses were called by the Salimi defence, and Mr. Salimi exercised his right not to testify. As a consequence, before this court, none of the words that were supposedly spoken by Mr. Salimi in any of his SPO interviews or his previous interviews were tested, contextualised or verified by him. He didn't correct or clarify or amend any of these interviews relied upon by the prosecution, as opposed to the many SPO witnesses who pored over their previous statements, often with the assistance of counsel, and who often provided substantive and wide-ranging corrections or amendments to them, often with little explanation for the reasons behind these changes. Mr. Salimi never had to take an oath before your honours to attest to the accuracy of the evidence he gave to the SPO. As the panel is well aware, the heightened review and scrutiny imposed on witnesses who appear to testify before the KSC seeks to ensure that any errors in previous statements can be corrected. And as a consequence of this, any errors, omissions, exaggerations, erroneous opinions, or oversights in prior interviews of Mr. Salimi, or his in his SPO interviews or other interviews, or testimony in prior proceedings, were neither corrected nor clarified. Given that he was being asked about events that occurred at least 20 years previously, with little context or background, and answered these questions without notes or even reference to source materials, it's unsurprising that there would be certain errors in them. Now, the prosecutor stated on Tuesday that you rarely see a final brief more dismissive of what their client said than that of the Salimi defence. That's transcript page 28515. That may be correct. Yet Mr. Salimi is not facing charges for being an unreliable narrator or even for failing to remember events that occurred so far in the past. Mistakes, errors, or omissions, in his recollection, all could and possibly do undermine the reliability and weight of his evidence. Now, as ever, the panel must be fully aware of all of these factors, as well as the severe limitation imposed by the appeals panel when assessing the weight to be given to his evidence. Now, with that procedural issue addressed, I'd like to move now into the substance of addressing the joint criminal enterprise charged by the prosecution in this case. And I want to say very clearly at the outset, there was no JCE, there was no joint criminal enterprise involving Mr. Salimi and his co-accused at any stage in the indictment period. That is, has been, and remains the primary position of the defence. In the absence of a joint criminal enterprise, there can be no liability for Mr. Salimi for committing crimes through this mode of liability. And we say that for various reasons, but principally that the SBO's case on joint criminal enterprise is deficient in logic, it is deficient in evidence, and this permeates every aspect of the JCE. And I will divide up the joint criminal enterprise by these different aspects as I go, starting with the objective of the JCE. Now, Your Honours are fully aware of the JCE as pleaded in the indictment. In paragraph 32, that between at least March 1998 and September 99, the accused and other members of the joint criminal enterprise shared the common purpose to gain and exercise control over all of Kosovo by means including unlawfully intimidating, mistreating, committing violence against and removing those deemed to be opponents. Now, as we repeatedly raised in our preliminary litigation and in our opening statement, in and of itself, this purpose to gain and exercise control over Kosovo is not inherently criminal. Far from it. It's the only way to stop the brutal and systemic oppression of the Albanian population of Kosovo by Milosevic's violent forces. Now, in these circumstances, where the objective of the JCE is not inherently criminal, such as would be the case for a joint criminal enterprise to commit murder or torture, the defence has challenged whether JCE liability can even properly arise. We highlighted this in paragraphs 567 and 568 of our final trial brief. Now, while some courts have allowed for criminal liability where the JCE simply contemplates crimes within the statute as a means of achieving this objective, we say that this impermissibly expands the form of liability created by the Tadic Appeals Chamber. Now, when we raised this before, in pre-trial litigation, it was held that the legal definition of the common purpose and requirement of a JCE with a criminal purpose were issues to be addressed at trial. So we say that the form of the SBO's pleading in this case and the way this case is presented is a central and live issue for adjudication by Your Honours. Now, finally, in the final brief at paragraph 7, and also in the opening statement at page 28362, the prosecution stated that JCE members, quote, in order to achieve the alleged goal of gaining and exercising control over all of Kosovo, committed crimes against their perceived opponents. Now, this formulation appears to recognise that the commission of crimes must have been the principal way in which the common plan was implemented. It was not merely an...
The interpreters kindly ask the speaker to slow down, please.
Impressed I managed to get 13 minutes in, Your Honour. My apologies to the interpreters. I will try and slow down. Sorry, I'm just going to go back to where I was. The commission of crimes must have been the principal way in which the common plan was implemented. Sorry. They cannot merely be incidental to the common plan. This is how the SBO's case must now be understood. It is not enough for the SBO to simply bring evidence of a non-criminal purpose, in this case, to gain and exercise control over all of Kosovo, if that did not necessarily encompass and was not necessarily achieved by crimes. And the crimes set out in paragraph 32 of the indictment. And we say that is how you, Your Honours, have to assess the JCE. You have to be confident that it was agreed that the objective would principally be carried out by those crimes listed, not that they were merely incidental to its execution. Now, on the issue of the non-criminal objective at the heart of the prosecution's case, the theory of the prosecution appears to be that the driving force for the accused, including Mr. Salimi, was not, therefore, the liberation of oppressed people within his country, but merely the selfish pursuit of power. Now, if this theory is to be believed, and this is the theory which goes to the heart of the prosecution's case, Mr. Salimi and his co-accused not only managed to pull the wool over Adam Yashari's eyes, but also managed to manipulate or dupe the many thousands of volunteers who risked and on many occasions gave their lives fighting for the KLA. We say this is the prosecution's theory is thus as offensive as it is unsubstantiated. Now, in relation to the purposes behind the JCE, we heard from the prosecution on Monday about additional purposes alongside that which is pleaded in the indictment. And they stated that a KLA objective of achieving independence in Kosovo in no way negates the objective and the part of the JCE members to gain and exercise control in the manner charged. Indeed, rather than being a counter-indicator, logic dictates that independence would have to be a prerequisite for them to have fully obtained such control. And it's a matter of common sense and established jurisprudence, according to the prosecution, that a person can have multiple simultaneous objectives. And then made reference to Radovan Karadic's, the finding in the case of Radovan Karadzic that he had participated in 4 separate JCEs. Now, it's wholly unclear on this point if the prosecution is alleging that independence is therefore a separate purpose that's running alongside the alleged purpose at the heart of the JCE in this case. Is this an objective or purpose of these accused, or just other accused alongside these? Was this independence also sought to be achieved by unlawful means, or was this merely to be achieved by lawful means? If there's a lawful objective that operates alongside the SPO's alleged common criminal plan, the SPO has not explained how Your Honours are supposed to determine which actions were directed towards this common plan and which actions were not directed towards it. In many ways, the prosecution's submissions on this motive, this purpose, raises many more questions than it answers. In relation to Mr. Salimi directly and individually, the evidence does not support a finding that he in any way agreed to gain and exercise control over all of Kosovo. Now, despite, as you're aware, being involved in fighting for many years before the indictment period as part of clandestine guerrilla forces, his motivations were not personal power. His motivations were simply the liberation of his people. And that, I would suggest to you, is demonstrated by his own actions after the indictment period, and during the indictment period as well. He never actively sought to be appointed to positions of authority. No evidence suggests that he sought to be appointed either as Inspector General or Minister of Public Order. When the PGOK ceased functioning at the end of 1999, he didn't seek political power. He became a commander in the Defence Academy and a commander of training in the TMK. He didn't enter Parliament until a decade after the war had finished. these facts are not consistent with the blind and unending pursuit of power that the prosecution appears to attribute to him. I'd like to move now to the members, or the alleged members, of the joint criminal enterprise. And the prosecution told us clearly on Monday, conviction and sentence are not sought against the general staff, nor against the KLA. Equally, no conviction is sought and no sentence can be imposed on the sole basis of being a member of the general staff or of the KLA. We, much like I believe the Thaçi defence, agree wholeheartedly with these fine words. Yet this is exactly what the SBO is seeking to do through this case, by relying on generic and speculative assertions in relation to both the general staff and the KLA as a whole, to compensate for the evidentiary gaps in its case. Now, as we highlighted at paragraph 573 of our brief, persons with a common objective are not necessarily members of a JCE. It is the interaction or cooperation among persons, their joint action, which makes these persons a group. Joint action among members of the joint criminal enterprise must be proven. So it's not enough for the SBO to show that Mr. Salimi and other alleged JCE members had a common objective. They must prove that these individuals acted jointly in furtherance of this objective. But the SBO has replaced this requirement of joint action with one of collective responsibility. Although they sound similar, the differences could not be more stark. Now, to overcome the absence of evidence of specific discussion or agreement to any particular policy, the SBO relies on the default position throughout its brief of collective agreement, collective decision-making or collective deliberation. Now, this is encapsulated in paragraph 64 of the prosecution final brief, where the SBO asserts that members of the KLA leadership and command structure have confirmed that the general staff gave orders to kill and detain collaborators. Deputy Commander 4401, for example, confirmed that while there were not written documents for specific cases, there was a collective decision of the general staff authorizing further measures for collaborators. As I mentioned, the SBO makes multiple other allegations of the general staff having met and coordinated frequently as part of a collective decision-making process, that's paragraph 103, or having collective deliberation. There are multiple other references to collective decisions within the general staff. Now, notwithstanding the defence's multiple challenges to whether these assertions accurately reflected the witness's evidence upon which they're based, they also highlight the extent to which the prosecution cannot demonstrate Mr. Salimi's individual agreement to the alleged underlying criminal purpose. It does not reference to collective decision-making, collective deliberation, doesn't prove that Mr. Salimi individually agreed with such policies, and the SBO has completely failed to individualize the allegations against him. Now, on Tuesday, the prosecution tacitly accepted this gap in his case, claiming this isn't guilt by association, this is guilt by purposive affiliation. It's transcript page 28529 to 28530. Now, I have to commend the prosecution on making an absence of evidence appear as a legal concept in their favour. The concept of purposive affiliation is nothing more than the tacit acceptance by the prosecution of the flaw in the heart of its case. It cannot and has not individualized the actions of Mr. Salimi or any of the accused. This is demonstrated in at least three different ways. First, the communiques, which are extensively relied upon by the prosecution. No testable and reliable evidence has been provided as to who wrote them. No general staff member confirmed that there was a discussion of such communiques. No meeting notes of general staff meetings refer to any such discussions. There's simply no basis to attribute responsibility to all of the accused for these communiques. Secondly, meetings that supposedly took place within the general staff or between the general staff and zone commanders. There are huge gaps as to who attended which of these meetings and when, and where or how information was shared from those meetings. Third, orders issued by the general staff to demonstrate the general staff's perceived attitude towards collaborators. There's no evidence that Mr. Salimi was aware of, involved in, or even supportive of these supposed orders. That Mr. Salimi was so involved simply because of his position on the general staff or presence in Kosovo at the time is nothing more than an assumption by the prosecution. The prosecution at paragraph 110 alleges that 29 meetings of the general staff occurred over the indictment period. Yet the existence of most of these meetings are noted simply by a tangential reference in a witness statement or another document. Even where some record of what was said in a general staff does exist, this is often no more than an unattributed handwritten note of bullet points without any information on attendees or who had said what or who had agreed to what. For a vast number of these meetings, no records exist at all. And as a consequence, Your Honours cannot be sure in any way what Mr. Salimi did or did not agree to as part of the general staff, what he was supportive of or not supportive of as a part of that body. Nor can you be confident of what he was aware of because of supposed reporting to the general staff as a whole. Your Honours heard many, many times throughout the trial reference to the general staff as a whole. I told the general staff, this information was sent to the general staff. This is such a generic allegation that the prosecution relies on to attribute responsibility to everybody within that organisation. Generic references to reporting from the zones, be they military, police, intelligence, any KLA personnel, simply do not demonstrate that specific information was provided to any individual alleged JCE member, and certainly not to Mr. Salimi. Now, in relation to the actual individuals that the prosecution does allege to be members of the joint criminal enterprise, these are listed as Azam Zula, Fatmi Limai, Lahi Brahimai, Suleiman Salimi, Rustam Mustafa, Shukri Buya, Latif Gashi, and Sabit Getzi. That's paragraph 35 of the indictment. Now, the SBO seeks to rely on supposed political and ideological affiliations between these individuals. Which occurred before the indictment period, including Mr. Salimi. In particular, that he was a member of the LPK and as a consequence had these links with the accused and other members through this body. Now, the defence has addressed this in detail at paragraphs 307 and 310 of its brief. But no other real connections between Mr. Salimi and either Mr. Kresnici or Mr. Vaseli before the indictment period were established. So instead of evidence of these relationships and this agreement between different members of the alleged JCE, the prosecution relies on irrelevant considerations which postdate the alleged formation of the agreement and even the indictment period itself. For example, the prosecution relies on Mr. Limai, Mr. Zula, and Mr. Salimi joining the initiatory council of the PBDK in October 1999, after the indictment period. which is wholly irrelevant to the question of whether there was a prior agreement between them to form a JCE. Mr. Salimi's connection with other non-accused alleged JCE members, non-accused alleged JCE members, also appears to be based entirely on incidental personal interactions, rather than any proof of an alleged agreement between them. For example, all of the accused are alleged to have stayed at Lahi Brahimai's house. This was in Jablanica before the indictment period. Mr. Salimi is alleged to have had a relationship or to be close to Sabit Getsi because apparently he left from Sabit Getzi's house when he went to make a speech for the first public appearance of the KLA. The SBO even throws in Mr. Lustaku as well, arguing on Monday that he was an old comrade of Mr. Salimi. And the same applies to Remy, who was alleged to be a close associate of Mr. Salimi, and Adam Yushari, who was with Mr. Salimi and Adam Yushari before the fatal assault on the Shari compound. The SBO's desperation to show or to demonstrate some link between these individuals, these alleged JCE members, is epitomized by these irrelevant factors. Passing through Mr. Getzi's house or Mr. Brahimai's house with no evidence of any role, discussion or agreement that they may have had as a consequence of this interaction is not evidence worthy of its name. Now, most notably, the prosecution refers to Fatmir Limai living together with Mr. Salimi as somehow suggesting some relationship between them that forms apparently the basis for the agreement underlying the criminal plan. And this was, I think, repeated by the prosecution on Monday during its oral submissions. Now, there are many allegations against Mr. Limai in the final brief of the prosecution. And Mr. Limai is not an accused here and is unable to defend himself against these allegations. But it's difficult, seeing the scope and nature of these allegations, to avoid the conclusion that Mr. Salimi is often nothing more than a proxy for Mr. Limai. Allegations which are principally directed towards him are transferred to Mr. Salimi in his absence, simply because of Mr. Salimi's personal relationship with Mr. Limai. That is entirely improper. And finally, in terms of names of alleged JCE members, the name that hovers over the entire case, or the entire JCE, that must be spoken about at this stage, is that of Adam Yushari, whose shadow cannot but fall over this entire case. Mr. Yushari is mentioned as being involved in fighting around Prekaz in early March 1998 by the prosecution. That's in their brief, paragraph 1333, despite obviously downplaying the cold-blooded massacre of his entire family. He's also mentioned at various other times in connection with the accused, such as meeting Mr. Thaçi and Mr. Veseli in 1992, that's paragraph 788, or being introduced to Mr. Salimi by Suleiman Salimi in 1994. And also, that's paragraph 98, and also around the 4th of March 1998, meeting Mr. Salimi, Sabit Getsi, Suleiman Salimi, Remy and Ramon Rama to discuss KLA expansion and improved weaponry. Now, the implicit conclusion that the SPO, that is being drawn by the SPO from these assertions, is that these connections between the accused and Mr. Yushari were somehow relevant to the SPO's case on JCE. And this, I would suggest, is because the SPO considers that Mr. Yushari was an unnamed alleged JCE member. No other reason can justify such reference to him. It's an inescapable consequence of the breadth of the JCE that's pled by the prosecution, which sweeps up everybody and every senior KLA member in its wake, even Mr. Yashari. But even now, I have little doubt that the prosecution would refuse to answer a straight question if you asked them, was Mr. Yashari part of the JCE that you alleged? If it was really their case that he was, they should own it transparently and openly. But like much of their case, Your Honours, they hope that you will gloss over these difficult questions. You must not allow them to do so. I'd like to now address the issue of opponents, or alleged opponents, as set out in the prosecution indictment. And first, in relation to the definition of collaborators. And the starting point in relation to collaborators must be that individuals who are perceived to be on one side of a party to a conflict, but in reality are assisting the other side, can be a legitimate cause of concern. I also wish to highlight that, as recognised by the prosecution, detention may be lawful and legitimate where there are reasonable grounds to believe that security concerns make it absolutely necessary, in reference to the appeals panel in Sharla, that there must be serious and legitimate reasons to think that the person concerned by his activities, knowledge or qualifications represents a real threat to the detaining power's present or future security. Now, undoubtedly there are different interpretations, there are significantly different interpretations of what constituted a collaborator amongst SBO witnesses and amongst the evidence in this case. And the absence of an agreed definition was raised by both the prosecution and defence in final submissions. The SBO's case is essentially that no formal definition of collaborator was ever provided by the General Staff as a deliberate choice of the JCE members within it, because this allowed JCE members to target more individuals as collaborators. This is my understanding, at least, of the prosecution case. Yet there's no evidence that the accused actually sought to deliberately abstain from defining collaborators because they sought a wider definition. This is, like much of the prosecution's case, mere conjecture. No meeting notes, no witness evidence supports such an avoidance of giving this definition. Indeed, evidence that there was no written definition of collaborators by the members of the General Staff does not constitute or even suggest a deliberate refusal to do so. Moreover, in relation to Mr. Salimi, the evidence suggests that his understanding of what constituted a collaborator was also narrowly defined. And this is, I'd like to demonstrate by two allegations in the prosecution's brief. Both that he defined collaborators narrowly himself and wanted that to be followed. Now, first, in relation to an individual detained in Licots in August 98. Now, this has been addressed at length in the defence final brief in relation to his detention. Now, while the defence contests Mr. Salimi's identification in this interrogation, the prosecution's case is that in Mr. Salimi's presence, a detainee was questioned about his alleged collaboration with Serbian officials. And the evidence is that this individual, identified as Mr. Salimi, then advised the individual who was interrogating him to let him go after he was interrogated. The individual ignored this request. So Mr. Salimi, even after hearing that this person was supposedly a collaborator, suggested to the individual interrogating him to let him go. He didn't believe he was anything like it. So even on the prosecution's case, Mr. Salimi didn't consider this individual as a collaborator and didn't want measures taken against him. Second, in relation to an individual in the LAP zone. Now, the prosecution alleges in paragraph 857 of its brief that Remy authorised the arrest of this individual as an alleged Serb collaborator who was detained in Bajgore. As the SPO then asserted, this individual, who had connections to the General Staff, was subsequently released from detention after the General Staff intervened and remained under Remy's supervision. Now, while again the defence contests that Mr. Salimi knew that this individual was actually arrested and detained by the LAP command, even though he was a former member of the Serbian police, Mr. Salimi, on the prosecution's case, wanted him to be able to fight for the KLA. This again undermines any wide definition of collaborator attributed to Mr. Salimi. No other interaction with an alleged collaborator who was subject to detention was alleged by the prosecution against Mr. Salimi. Now, while there is another allegation in relation to an incident in Klečka in April '99, which I'll get to later, this is strongly contested by the defence, as set out in the defence brief. But even on the prosecution's case, this individual was not a collaborator, but was a member of the KLA who was detained for disciplinary offences. As a consequence, he is not, therefore, a collaborator on their case. And the SPO has not adduced evidence that Mr. Salimi thus had a wide interpretation of collaborator, or even sought for such a wide interpretation to be implemented by others within the KLA. As for the second category of opponents, the prosecution's case on this is very weak, confused and contradictory, as best demonstrated by the evidence in relation to the LDK. Now, we know there's not one definitive LDK viewpoint on the aims and means of the KLA. Now, while there was traditionally a policy of non-violence, the LDK was a large tent encompassing a variety of viewpoints. And indeed, as explained by various prosecution witnesses, many LDK members became members of the KLA. In fact, being an LDK member was not a bar to admission. By the time of the indictment period, many LDK members believed that it was necessary to take arms to achieve their aims as well. And even members of the government in exile were reconciled to the need for armed force to be used to achieve their own liberation. That was the reason behind the Oslo talks in May '98 and the eventual agreement that was signed by the end of the year. There was not a particular viewpoint against the aims and means of the KLA. And I wish to move to the implementation of the common plan, or the alleged implementation of the common plan, according to the prosecution. Now, the prosecution's case on this is that this common plan was implemented largely through orders and communiques. I know it was also alleged that it was implemented through regulations, but this has already been addressed. Now, while the defence has already set out in detail the absence of Mr. Salimi's role in creating or preparing any of these types of documents, the evidence on the documents themselves does not support the existence of a common plan to unlawfully target opponents. Now, the primary argument of the prosecution, set out in paragraph 67 of its brief, is that communiques served a dual purpose. They constituted both instructions that were disseminated to zone commanders to target collaborators and warnings to potential or actual opponents. Yet neither of these purposes is supported by logic or the prosecution's evidence. In relation to the argument that they constituted instructions, this is also alleged in paragraph 358 of the prosecution brief in relation to the LAP zone, where it alleges that the LAP zone command treated General Staff communiques as directing and authorising the treatment of collaborators and those perceived as obstructing the work of the KLA. Now, this argument derives entirely from the evidence of 4746, whose evidence on this part of the case is wholly unconvincing. He does not specify, this witness, 4746, which specific communiques instructed him to take measures against opponents, which makes it impossible to verify whether they actually did. Now, he refers to communiques 53 and 54 as potentially the basis in his SPO interview. Yet, communique 53 states that punitive actions are being taken against collaborationist elements by the General Staff, and communique 54 provides that those who conduct special warfare will be treated in accordance with the laws in wartime circumstances. At its very highest, this can be said to inform anyone reading the communiques of measures that the General Staff would be taking in accordance with the laws in wartime circumstances in relation to collaborators. It cannot constitute an authorization, either explicit or implicit, that such measures can be taken by the zones or below. Nor did this witness even specify the measures that he considered these communiques authorized him to take. He didn't specify that they authorized him to arrest or detain collaborators or explain how that was the case. Further, and I believe this was already mentioned by counsel for Mr. Thaçi, such detentions had already been undertaken in Bahre and by Gore, according to the prosecution's own case, since the 2nd of August 1998, well before these communiques were actually issued. And this is confirmed by P167, which is a decision on the release from one of the individuals detained in August and September in the lap zone, which doesn't make any reference to General Staff communiques at all. Furthermore, as a question of logic, if the SPA's theory is correct, then the communiques were openly instructing those at the zone level to carry out crimes against opponents. Why did the zone commanders thus not carry out such acts openly and inform the General Staff members accordingly? Why was 1D29 issued to take measures against the potential for such crimes if these crimes against alleged collaborators were so intended by General Staff members as a whole? Why did zone commanders make efforts to hide these detentions or acts of mistreatments from members of the General Staff? This absence of logic or absence of coherence within the prosecution theory is startling. Other zone commanders or members of the General Staff who testified as SPO witnesses also didn't confirm this theory or this interpretation by 4746. 4401, for example, was asked about this and explained that it was nothing more than a personal interpretation by him of the communiques. Again, without specifically identifying any communique which set out a purported instruction. There is also another fundamental logical incoherence between the reliance upon General Staff communiques as the basis for instructions to zone commanders and specific orders that were issued by the KLA General Staff. If communiques so clearly and unequivocally and directly instructed the zone commanders to detain collaborators, why would you need to issue orders later on as well? Why was P168 issued on the 2nd of December? The reality is that communiques made no such authorization, and it was entirely unreasonable to suggest that they did. As for the second part of the prosecution's case on communiques, namely that communiques celebrated the deaths of collaborators as warnings to everyone else, again, the communiques do not support this interpretation. Now, this is raised at various different times throughout the prosecution brief, but is most summed up in final brief, paragraph 60, in relation to communique number 28. Now, at the outset, Communique 28 is from January 1997, before Mr. Salimi or any of the accused were General Staff members. But if warnings to collaborators were one of the central purposes behind the communiques, they would have to have sufficient credibility. A reader would have to believe that the actions described in them had actually been carried out. Yet the prosecution brought no evidence that this was the case. Furthermore, the prosecution has not listed as a victim within the indictment any individual who was actually mentioned in a General Staff communique as being a collaborator, and against whom measures had already been taken by the General Staff. This reinforces that the names that were set out in communiques were largely, if not predominantly, propaganda. Now, on Monday, the SPA challenged the dismissal of communiques as propaganda because they had listed examples of actions taken against collaborators in paragraphs 1473 and following of the prosecution brief. Now, that's correct to the extent that they repeated the names that were listed in those communiques, but doesn't demonstrate that they actually tendered evidence to suggest that those events had taken place, as described in the communiques. Now, conversely, if victims listed in the indictment were within the group of opponents and measures taken against them were intended to be warnings to collaborators, they would have been specifically mentioned in the communiques as having been killed because of their collaboration. It's the only way in which such warnings would have effectively functioned. I've already addressed that. Sorry, let's move on. So, finally, just on this point, the defence notes Communique 59 and the evidence of 4401 on this topic. Now, neither of these two pieces of evidence undermines the contention that communiques didn't form the core of the JCE as the SPO alleged. 4401 did testify that communiques served as a warning, but were mostly propaganda. Now, in the same vein as his evidence in relation to the instructive natures of communiques, no specific communiques were referred to, and no specific basis for this contention was provided. The prosecution also relies in paragraph 322 of its brief on Communique 59, purportedly in support of its general theory regarding the purpose of collaborators. Now, in particular, the SPO alleges that a year after Communique 59 was published, after the war had ended and after the indictment period, Mr. Salimi continued to publicly further the narrative of Gani Getsi being a traitor and having killed Aberdeen Regia on behalf of FARC, with full knowledge not only of the falsity of that allegation, but also of the danger that it posed for Mr. Getsi and his family. Now, this is a particular case. While evidence on the authorship of the communique was limited, and is addressed in paragraph 612 and 615 of the defence final brief, Gani Getsi was being held directly responsible in Communique 59 for the death of a KLA commander, Aberdeen Regia. Communique doesn't state the measures had been taken against Mr. Getsi, or would be, or nor does it instruct others to do so. When Mr. Salimi spoke about this incident a year later, there was information that Mr. Getsi was responsible for Mr. Regia's death. Mr. Salimi in this article states that Regia's murder was described in Communique 59. The communique clearly states that he was murdered by Gani Getsi. He then repeated the allegation that Mr. Getsi killed Mr. Regia. No reference is made in that interview to Mr. Getsi leading Serb forces or being a branded collaborationist. Indeed, Mr. Salimi merely asks rhetorically whether the question was politically motivated and recalls the need to analyse who killed him and why. Now, the issue before your honours is not whether Gani Getsi killed Aberdeen Regia, or even whether Mr. Salimi was correct to accuse him of doing so a year later, on the 30th of October 99. What matters is whether this communique is consistent with and demonstrative of the SPO's theories that communiques were used to target opponents. Mr. Thaçi was not targeted by this communique because he was an LDK member, but because it was reasonably believed he had killed a KLA commander. This is a wholly different reason which falls outside the common purpose. And secondly, the SPO also claims that the General Staff issued orders and regulations which either facilitated or were specifically directed towards implementation of the common purpose. Yet a proper review of those documents demonstrates that such orders were directed towards the lawful organisation of unstructured units and further implementation of the rule of law, rather than the criminal purpose alleged by the prosecution. Now, the SPO claims that the General Staff issued orders for the creation of military police units and relies on different versions of an order, an unsigned order, purportedly issued on the 2nd of July 1998 by the General Staff for the military police to stop suspicious persons. It's P3675 and 3674. Now, these documents weren't shown to anyone. They were tendered from the bar table with no witness commenting or contextualizing them. No reference is made to opponents or even which individuals this order allegedly authorized the military police to detain. Similarly, in the order itself, the assertion that these orders included the establishment of detention facilities and the detention of collaborators, again, no written orders were specified by the prosecution, and only the vague and unsubstantiated evidence of SPO witnesses 4746 and 4752 was relied upon. In any event, orders to establish the military police, detention facilities, or even detain collaborators cannot be considered to necessarily facilitate or be directed towards the alleged criminal purpose. Military police units undertook various acts for the functioning of the KLA that had nothing to do with detaining suspicious people. Now, similarly, given the prosecution's stated acceptance that detention is not inherently unlawful and the lawfulness of taking measures against purported collaborators, the mere creation of detention facilities doesn't by definition contribute towards a criminal purpose. And in this regard, the prosecution relies on three separate orders: P741.3, P168, and P1017. Yet it's unclear from the prosecution's case whether these three orders are supposedly indicative of the common purpose being ordered by the General Staff, or on the contrary, that the General Staff was concerned about abuses being committed at the lower level and thus was taking measures to stop these crimes, as appears from the face of these documents. Again, these contradictions go to the heart of the incoherence of the prosecution's case. So therefore, the 28 November 98 order issued by Zerapi orders that commanders are due to increase checks and that improper behaviour towards the civilian population is to be prevented in all KLA units. They are consistent with the General Staff taking measures contrary to the implementation or the alleged implementation of the JCE. P168. The second order specifically relied on, relates to a very specific threat posed by individuals who were armed as local police within the Serb forces in Jakova. Now, while the SPO alleges that local police members were not part of the Serbian armed forces, in the prosecution brief 297, paragraph 297, there is evidence that such individuals were directly armed and equipped by such forces, as confirmed by the very witness relied upon by the SPO. These were not friendly, unarmed community policemen, as the prosecution suggests, but well-armed, well-equipped individuals fighting against the KLA. And the last document is P1017, was admitted through W4576, based on what can only be described as a convoluted process of displaying the document and suggesting to the witness that it was similar to a document in his book, a proposition that the witness was loath to confirm. While Your Honours did finally admit the document into evidence, it did so with the following caveat, and that's transcript page 12700. The court will admit the document, but it has very hazy evidential value. The weight will have to be determined later on, and it's possible that it does not receive very much weight at all. Very much weight. As the SBO has not sought to contextualize this document with any witness and specifically didn't show it to 4752, no weight can be reasonably be given to it by the panel. Your Honours, coming to the end of the first half of my presentation, the SPO's case on joint criminal enterprise is illogical, incoherent, and unsupported. Despite the prosecutor's fine words, it is based on guilt by association, collective general staff responsibility, unsupported and speculative opinions of witnesses, unattributable public statements, and insinuations which do nothing to mask its inherent inadequacies. And I will move on after the break to Mr. Salimi's alleged role within this JC. Thank you.
Thank you. We'll be adjourned until 3:45.
All rise. All rise.
Be seated, please. All right, Mr. Roberts, when you're ready, you may proceed.
Thank you, Your Honour. I hope to complete the rest of my presentation this afternoon. I may need to beg Your Honour's indulgence for an extra 5 to 7 minutes at the end if I get close to finishing, but I'll inform you accordingly.
Just keep us advised.
Thank you, Your Honour. Now, as I said, I'm moving on to Mr. Salimi's alleged contribution to the JCE. Now, as was held in paragraph 110 of the confirmation decision, that's F26, the perpetrator's contribution to the JCE need not be as a matter of law necessary or substantial, but it should at least be a significant contribution to the crimes for which he or she is found responsible. This has been explicitly accepted by the SPO during the prep conference on the 15th of February 23. It's transcript page 1964 and reflects findings in the Mladic 98, Rule 98 bis decision and Krajnic appeals judgment. This is not mere window dressing or an inconvenience that can be dismissed, but a central requirement for proving contribution to a joint criminal enterprise. None of the supposed contributions by Mr. Salimi to the alleged JCE passed this stringent test. Now, at the outset, some of the alleged contributions have no link whatsoever to crimes. For example, the prosecution alleges that Mr. Salimi was involved in organising weapons transports, paragraph 187, delineating zone boundaries, paragraphs 213 or 370, reinforcing existing units, paragraph 390, or authorising disbursements of funds, paragraph 206. Prosecution has done nothing, either orally or in writing, to demonstrate how these contributions significantly contributed to crimes in the indictment. None of the contributions or none of those examples are criminal or even tangentially directed towards crimes. They amount to nothing more than the general functioning of a nascent army. To ground liability on such actions removes any meaningful difference between culpable and non-culpable conduct. Similar contributions were carried out by tens or hundreds or sometimes thousands of KLA members. Were they all making significant contributions to a JCE? I think not. Now, the SBO's case in relation to Mr. Salimi and his alleged contribution is set out in paragraphs 528 to 543 of the SBO final trial brief. And I'll try and address each of these allegations in turn so that Your Honours are left in no doubt that no such contribution existed. So firstly, paragraphs 528 to 532, formulating, implementing plans, policies, rules, structure, and reporting. Now, in these paragraphs, the prosecution appears to rely extensively on Mr. Salimi's alleged position of hierarchy, in and of itself, as something or somehow contributing to the commission of crimes in the indictment. Now, we say this is manifestly insufficient. As recognised by the ICC pre-trial chamber in Embarishamana, albeit applying a different form of liability under Article 25 3D of the ICC statute. Quote, the evidence submitted by the prosecution is insufficient to substantiate the finding to the threshold of substantial grounds to believe that the suspect's role as a leader of the FDLR qualifies as a significant contribution to the commission of crimes by the FDLR. Now, I note that the SPO sought to dismiss the relevance of this case on Tuesday based on the different modes of liability. But the central principle that it holds is valid. A position of authority in and of itself does not amount to a significant contribution to crimes. The prosecution has done nothing to dispel this underlying reasoning. So in that regard, the SPO's claims regarding the appointment and authority of Mr. Salimi as Inspector General are wholly unconvincing. And although the defence dedicated a substantial part of its own brief on this aspect, 102 paragraphs by my count, from paragraphs 349 to 451, I wish to address a few small aspects of the SPO's submissions. First, the SBO claims that at least by July 98, Salimi had been appointed as Inspector General, yet relies on evidence in support which lacks any temporal specification or which otherwise highlights the existence of multiple conflicting accounts on this point. The SBO has not identified any particular document or witness statement which removes these ambiguities. And given the absence of documentary evidence as to Mr. Salimi's appointment to this position, or even witness evidence which states how and when this appointment occurred, the panel cannot be satisfied with any confidence as to when it did so. Now, second, in terms of his actual authority in this position, the prosecution asserts in its brief that in his capacity as Inspector General, Mr. Salimi was on the level of the General Commander, reporting directly to him, and in his absence, the Deputy Commander. That's paragraph 106 of the prosecution brief. Now, as with so much of the SPO case, this allegation is insinuated rather than stated clearly and unequivocally. Is it now the prosecution's case that Mr. Salimi was actually on the same level as the General Commander of the KLA, with the same duties and responsibilities as a kind of alternate KLA commander? Is that what we're supposed to understand from the final brief? And this appears to be the case because paragraph 529 says that as the General Inspector, Salimi was above the directorates at the level of the General Commander. Yet at no point in the SPO's case has the SPO formally alleged, let alone proven, that the Inspector General was at that level and had that authority. It was not made in the SPO pre-trial brief, where the SPO simply alleged that the General Inspector reported to the General Commander, with no allegation that he was on the level of the General Commander. This was despite the fact that the evidence derives from 4752 and Mr. Thaçi and a purported organogram, all of which was in the SPO's possession when they filed their pre-trial brief. No witness gave live evidence during trial on this point. Mr. Thaçi's ambiguous evidence during his SPO interview, which the SPO did not seek to clarify, cannot be relied upon, as Mr. Salimi couldn't test it through cross-examination. And it was not suggested to any SPO witnesses who could have provided evidence on this issue, such as 4401, 4752, or 4290. The evidence of 4752, this is P1355.7, page 23, when he was asked about the role and responsibilities of Inspector General, is as follows. Inspector wasn't on the same level, it wasn't equal to the other directorates, but it was on the level of the General Commander, which means that he received instructions from the General Commander in terms of the inspections that he would carry out, the tasks that he was assigned by him. So 4752's evidence on this point is not what the SPO implies. Being on the level of the General Commander meant simply that he received instructions from him. It doesn't mean that his authority in that position was comparable to that of the overall commander, as the SPO suggests. The remaining substance of 4752's evidence, as well as the evidence of various other witnesses and exhibits, also confirms that the Inspector General was not above the directorates, but on the contrary had a significantly lesser role and authority. For example, the Inspector General's role was novel and unclear both to him and to those with whom he interacted. Paragraphs 363 to 371 of our brief. He had no staff, subordinates, or reporting. Paragraphs 410 to 420. He had no authority over specific units. 421 to 429. He was not even invited to general staff meetings when they invited only the directors of directorates. Paragraph 380. Even in relation to the instructions that he received from the overall commander. 4752 confirmed that Azam Zula was out of Kosovo for a significant period, and it would have been difficult for Salimi to have reported to him during this time. Nor did he ever see a report exchanged between Zula and Mr. Salimi, nor was there evidence of any intercepted communication between them. There is no allegation by the SPO that any of the intercepts may provide evidence of this relationship. The lack of a defined role, and certainly not one that places the Inspector General above the other directorates, is also exemplified by the various versions of disciplinary regulations, which simply fail to even mention the position of Inspector General. For example, P715 is clear that the Inspector General has no authority in disciplinary matters. This was confirmed by 4769 and 4752 in relation to these regulations. And all one needs to do to confirm this is look at paragraph 125 of the prosecution's brief, when it states that General Staff Directorate heads and deputies, when leading GS inspection and monitoring teams, could issue warnings, discharge orders, and impose disciplinary confinement. The Chief of the General Staff, Commander of the KLA, Commander of Public Order, and Commander of the Intelligence Service, and the Commander's deputies could all issue disciplinary measures provided in the regulations. There is no mention of the Inspector General. The prosecution cannot, in good faith, simultaneously rely on this statement and not take from it the inevitable consequence that the Inspector General had no formal authority to take such measures, which completely undermines the SPO's assertion in court on Monday that as Inspector General, Salimi's function was operational, supervisory, and disciplinary. Indeed, the one document which purported to list his responsibilities, or a concept for his responsibilities, which was referred to by the prosecution, that's 3D 27, doesn't even refer to such disciplinary activities either. The prosecution has pointed to no formal KLA document, no order, no regulation that supports its blanket or assertion as to Mr. Salimi's authority. Instead, the SBO seems to rely almost exclusively on P3749, which is an undated, handwritten drawing purporting to represent the general staff structure at some point in its existence. This handwritten scrawl is neither official nor dated. There's no evidence on who prepared it, when and for what purpose. The fact it was found at Mr. Salimi's house doesn't provide any clarity on these issues. Its admission through the bar table at the very end of the prosecution's case, without any contextualization from any prosecution witness, deprives it of any weight. In terms of the document itself, the SBO has not presented any evidence that a structure of the inspectorate comprising inspectors, deputy inspectors, and subordinates was ever established. Indeed, the consistent evidence of prosecution witnesses was that it was not. Other unexplained factors like the red ink, which seeks to form some structure around the alleged inspectorate, which may or may not have been produced at the same time and by the same person as the original document, further reduce any reasonable reliance that can be placed on this document. Even the content of the document itself doesn't support the assertion that the Inspector General was on the level of the General Commander. At most, it posits the Inspectorate as subordinate to the Deputy Commander and somehow parallel to the military court. It posits Mr. Salimi as nothing more as an assistant to the Commander rather than endowing him with any substantive control. Later in this point, the SPO also implausibly claims that the Inspector General was a higher rank than the Chief of the Operational Directorate. Now, in addition to 4752's evidence, which has been addressed already, this is apparently based on Mr. Salimi's prior statements, where he confirms that he originally held the role of Chief of the Operational Directorate, and after this, the Inspector General. Yet, at no stage does he even suggest that the Inspector General was superior to the Chief of the Operational Directorate, and no other prosecution evidence supports such a theory. The prosecution's blanket assertions regarding the role and authority of the Inspector General are not built on solid, well-constructed evidential foundations. They're built on desperate assertions, on untested scrawls, and comments which the SBO misrepresents in order to buttress its flailing case. They do nothing more than highlight the absence of clear, concrete, and reliable evidence on this issue. Secondly, paragraphs 533 and 534, participation in crimes, or facilitating or encouraging crimes in furtherance of the common purpose. Now, in both the prosecution's final brief and over oral submissions, the prosecution cursorily and superficially addressed the individual allegations against Mr. Salimi. Now, the defence, by contrast, assessed and addressed these in detail over parts V5D 1 to 8 of the defence final trial brief, and there's little more that needs to be said. I will, however, address, in relation to each one of them, a couple of minor points. Now, first, in relation to an allegation involving Mr. Salimi stopping a man in a village in June '98 and purportedly intimidating him, the limited relevance or probative value of this assertion is demonstrated by the lack of prominence given to it by the prosecution. The same vague assertion regarding Mr. Salimi is cited in paragraphs 81 and 663 without any direct allegation or evidence against Mr. Salimi regarding what was actually said by him to supposedly intimidate this individual. We addressed this allegation in paragraphs 653 to 678. It's principally based on the evidence of one witness who fabricated evidence implicating Mr. Salimi and other individuals in earlier events in April 98, and whose evidence largely comprises untestable and uncorroborated hearsay from a deceased individual, which he also never mentioned in previous statements. His explanation of how he claimed to identify Mr. Salimi is wholly unbelievable, while the description of Mr. Salimi and its circumstances raises multiple elements of an unreliable and unsafe identification. Second, in relation to the allegation set out at paragraph 41 of the indictment relating to the alleged crimes in Drenots against two opponents in June 98. Now, as we set out in paragraph 680 to 682 of the defence final brief, the allegation of Mr. Salimi's presence in that allegation is not one of participation, as set out and accepted in filing F3607 at paragraph 38. The prosecution's belated attempt to involve Mr. Salimi as an active participant in this event, and I'm referring here to paragraphs 82, 534, and 767 and 768 of the prosecution final brief, is as unsubstantiated as it is procedurally improper, as is the prosecution's claim that Mr. Salimi's SPO statement on this issue was reliable as it implicated him and was thus against his own interest, as no such implication was made. As for the prosecution's vague and unreferenced oral assertion that this argument is illogical and unfounded, that's transcript page 28451, without any further explanation or substantiation, this is wholly meaningless. As the defence has set out in its brief, none of the accounts provided in relation to this incident are reliable. They are impacted by the interference in the investigation by outside individuals, which have compromised the reliability and credibility of the evidence produced. Third, in relation to Mr. Salimi's alleged presence in the vicinity in the aftermath of fighting in Rahavats in July 98. Again, addressed in paragraphs 782 to 816 of the defence brief, all the evidence suggests this was not an attack on Rahavats initiated by the General Staff, but instigated instead by local units of their own volition. Mr. Salimi was not present at the outbreak of fighting. He arrived later with 4752, with whom he remained on the front lines in the face of the VJ counterattack. His subsequent involvement in defensive actions to repel these attacks and swift departure to Lapushnik demonstrates the absence of any knowledge or role he had in relation to any individuals who were supposedly detained by local units in the context of this fighting. Neither the available documentary evidence, that's P1329, P67 or P643, nor limited witness evidence on this proves any role for Mr. Salimi whatsoever. Fourth, in relation to allegations against Mr. Salimi for being present during an interrogation of an opponent in Likots in August 98. These are addressed at 743, paragraph 743 to 766 of the defence final brief. I've already referred to it earlier. They're based on the entirely unreliable evidence of one witness who sought for the first time before this panel to also implicate Mr. Salimi in his beating, an allegation that he had never made before, despite multiple prior opportunities to do so. The lure of financial compensation, which the witness admitted being interested in to the SPO, strongly appeared to be enough for this witness to lie to the panel. Now, while the SPO quite rightly has not relied on this new and wholly fabricated part of his evidence, it's been unable to draw the logical consequence of this non-reliance, namely that the credibility of that witness is so low that it cannot be relied upon at all. Unsurprisingly, in its brief or orally, the SPO makes no reference to any of these issues, instead simply asserting Mr. Salimi's presence during that incident. The SPO does not even refer to the request that this individual be released, or that any mistreatment of that individual only occurred after the individual that was identified as Mr. Salimi was present. Fifth, in relation to the alleged intimidation of LDK-affiliated units in the Dukajin zone in early September 98. As alleged in paragraph 45 of the indictment, the defence has extensively addressed these allegations in paragraphs 817 to 881 of the defence final brief. The actions of Mr. Salimi were limited but justified in the prevailing context at the time. However, I would just like to recall the SBO's further insinuation of involvement by Mr. Salimi in an alleged plot to kill individuals repeated in paragraphs 339 of the SBO final trial brief. This appears to be an allegation based on the evidence of W04448 and epitomises the calibre, or lack of calibre, and lack of credibility of prosecution witnesses. 4448 had an extensive history of refusing to answer questions and manipulating the SBO when it suited him, as it had done prior prosecutorial authorities. His evidence before this panel was no different. Convincing a desperate prosecutor to write to US immigration authorities to assure them of the importance of his testimony appeared to be far easier for this witness than fulfilling his basic obligation to tell the truth before the court. One witness to whom his evidence related had a 0% confidence in the veracity of his evidence. Your Honours should have no more than that. Sixth, now in relation to the allegation at paragraph 46 of the indictment relating to the alleged participation of Mr. Salimi in the arrest, detention and intimidation of members of a parliamentary delegation in Chires. We fully agree with the prosecution that the panel must consider all evidence in its totality when addressing this allegation. It's a transcript page from the prosecution's submissions on Monday 28438. Yet when doing this, the panel must take into account the inherent contradictions between the witnesses' accounts on this issue, which the SBO has done nothing to reconcile, irrespective of which account the SBO relies on. This is amply addressed by the defence in paragraphs 882 to 922 of the defence final brief. But what is also noted, however, in the prosecution final brief is the extent to which the SBO has resiled from the initial allegations against Mr. Salimi in relation to this incident. Out of the 4 allegations that originally appeared therein against Mr. Salimi, only one barely remains, and even that is not supported by any evidence approaching the necessary level. Seventh, in relation to the arrest, detention and proceedings against Blair Mkuchi as set out in paragraphs 502 and 503 of the prosecution pre-trial brief, there is no direct allegation or evidence of involvement by Mr. Salimi for these actions. As explained in detail in paragraphs 1009 to 1049 of the defence final brief, the evidence on this issue is vague and limited. No suggestions of Mr. Salimi's involvement in the decision-making or implementation of these actions has been demonstrated. In any event, the individual purported victim of that allegation is not, we say, an opponent within the SBO's definition as set out in paragraph 32. The same applies to the 8th allegation against Mr. Salimi, as set out in paragraph 49 of the indictment in relation to an incident in April 1999 in Klečka. This incident was repeatedly referred to by the prosecution and also by Victims' Counsel on the 2nd of February. Now, at the outset, I just want to note that, like all allegations in the indictment, Mr. Salimi is not charged with physically committing any crime in relation to this incident. That was clearly notified by them and referred to in the defence final brief. In any event, the uncorroborated and fabricated identification of Mr. Salimi along with a wholly invented story of how the witness concerned previously claimed to have met him in order to be able to subsequently identify him, is wholly unreliable. The prosecution has done nothing, either orally or in writing, to dispel any of the legitimate criticisms about this identification, and has merely restated its contention as if none of those exist. Your Honours will recall that witness's fantastical and convenient description of Mr. Salimi appearing under a moonlit sky a few weeks before the incident concerned. Such a patently fabricated explanation should prevent the panel from relying on a single word of his testimony. But even if the panel does consider that this evidence was somehow given honestly, the many crucial and fatal issues undermining his claimed identification of Mr. Salimi, wholly ignored also by the prosecution in writing and orally, were extensively set out in paragraphs 934 to 977 of the final trial brief. This identification is fundamentally unreliable. Ninth, in relation to Imer Shafici, the SPO relied upon the testimony of W3724, who was informed by a person associated with Mr. Salimi's nickname of 10 that Shafici was under the control of a higher formation. And this witness was one of two witnesses to testify before the court regarding Salimi's knowledge of this abduction. That's a reference to transcript page 28415, the prosecution's submissions on Monday. However, what the prosecution failed to relate was that this witness did not make the association himself, but was told it by a colleague who didn't testify, and 3724 himself had no knowledge of what 10 was, as he candidly admitted to the panel. As for the other witness euphemistically referred to by the prosecution as testifying regarding Salimi's knowledge of this abduction, this unreliable identification, which was again challenged in detail by the defence, didn't confirm that the individual identified as Salimi actually had any knowledge of that detention, simply that he had been asked about it. And finally, there are two other allegations which the prosecution should not be maintaining, but still surreptitiously appears to be doing so. And one relates to an allegation that Mr. Salimi threatened a journalist and human rights activist in October 98 in Jablanica, as set out in paragraph 47 of the indictment. This was based on evidence of one witness, whose evidence was admitted pursuant to Rule 155, without the evidence specifically relating to Mr. Salimi, because, in the words of the trial panel, the allegation was and would be uncorroborated. It was given by a witness whom the accused, Mr. Salimi, would not be able to cross-examine and challenge in respect of these assertions, and was not given under oath. As such, it was excluded as causing undue prejudice, outweighing the probative value of that part of the witness's evidence. And for the record, that's decision F1603, paragraphs 193 and 197. And the prosecution was ordered to prepare and tender a version of that document, redacting the impugned section. The prosecution explicitly withdrew this allegation from the indictment in filing F3155. But yet in paragraph 345 of the final brief, it alleges that members of the General Staff were also directly implicated in the targeting of opponents in the Dukajin zone. In late October 1998, an opponent was escorted to the Jablanica headquarters, where he was interrogated by a man who identified himself as, and Sokol de Bruyne confirmed was, a General Staff member. This assertion is based on 3 paragraphs of the witness statement, which the SPO did not redact. These other paragraphs continue indirectly to implicate Mr. Salimi in the incident in contravention both of the trial panel's order and their own notice. We say it's wholly improper for the SPO to continue to rely on these allegations and to seek to implicate both Mr. Salimi individually and the General Staff as a whole in relation to this incident. And finally, in relation to individual allegations, the SPO also alleges the involvement of Mr. Salimi in relation to an individual called Sami Duga at paragraph 1005 of the SPOF final trial brief. It's not mentioned at all in the pre-trial brief. There is an allegation in paragraph 513 of the pre-trial brief, which relies exclusively on the evidence of 4839 in relation to an alleged order from Mr. Salimi regarding an individual from Duga village, but this was later withdrawn. Sorry, yes, the order was later withdrawn. And again, when Your Honours admitted 48389's testimony or evidence in decision F2013, you noted this wasn't contained in the indictment, nor that the individual was in fact killed, but considered this evidence would be relevant, and again, you excluded it due to the undue prejudice it would cause. However, the prosecution appeared to have resurrected this allegation in paragraph 1005 of the prosecution final trial brief in a different form, potentially in relation to a different Duga. Either way, this allegation should not have been led against Mr. Salimi. Third, the failure to prevent, investigate or punish. So this is paragraphs 535 and 536 of the prosecution final trial brief. Now, this is essentially an aspect of superior responsibility that has been repackaged as an alleged significant contribution to the JCE. Mr. Salimi did not have subordinates. He did not have the authority to release detainees. The perception of Mr. Salimi's authority by 4743 in relation to one specific case relating to 4 military police members who were not charged with any underlying crimes in the indictment is vastly different to his actual authority and irrelevant to the allegations in the indictment. Other aspects of his alleged knowledge of crimes through media broadcasts were addressed extensively by the defence in paragraphs 1131 to 1153 of the final brief. Fourth, dissemination of information to promote the common purpose and engender fear, distrust and hatred. Prosecution final brief, paragraph 537. Now, this allegation for disseminating information is notably limited even within the limited scope of the prosecution's allegations as a whole. First, the prosecution relies on Mr. Salimi's role at the initial appearance of the KLA in November 97, well before the indictment period. Now, while I'll address the content of this later in relation to Mr. Salimi's intent, the fact that it was made over 5 months before any crimes were committed pursuant to the alleged common plan during the indictment period means it cannot have constituted such a significant contribution. No link has been demonstrated by the SPO between that speech and specific crimes they allege in the indictment. Similarly, the SPO's assertion that Mr. Salimi took part in communications governance during the war to ensure that the General Staff's official public statements would be perceived as authoritative, it's a quote from the prosecution brief, is as meaningless as it is unsupported. The evidence relied upon is the relatively uncontroversial statement by 4410 that when he met Mr. Salimi, he commented that he was happy the witness had gone to see the war, but had some remarks concerning the way that Albanian television was informing about the war because the reporting was not the real reflection of the situation there. 4410 never explained how this relatively benign comment, which he agreed with, constituted Mr. Salimi ensuring that the General Staff's official statements were authoritative. Any request for a realistic and objective assessment of the conflict from those who actually visited the war zone is entirely contrary to the SPO's suggestion that Mr. Salimi was seeking to control the messaging or to put out a specific position. 5, appointing, promoting, approving appointments and promotions. Now, the defence has addressed the role of Mr. Salimi and the General Staff in appointments of military police at various aspects of the defence final brief, at paragraphs 237 to 276. The vast majority of appointments were actually carried out by the relevant zone commander with no role or implication of Mr. Salimi or any members of the General Staff. But there are two aspects which merit some brief further comments. First is the Personnel Council and Personnel Directorate. Now, the prosecution appears now to be placing weight upon the fact that the Inspector General had a role in relation to the Personnel Directorate, claiming that at the General Staff level, the Personnel Directorate cooperated with the Inspector General. That's paragraph 177 of the final brief. But yet again, the prosecution overstates this evidence. In this case, an interview of Adam Grabowski, who actually states that the closest cooperation was with other directorates and on occasion with the Inspector General. Again, this untested individual evidence from an individual who was not called as a witness should be ignored by the panel. The SPO also alleges that Mr. Salimi was a member of the Personnel Council. It's paragraphs 178, 538 and 539 of the prosecution brief, allegedly responsible for examining a proposal for appointment, including from the zones, which would be discussed by the General Staff. This assertion rests on two handwritten notes, both referring to the establishment of various committees. Mr. Salimi's name only features on the undated note as a member of the Personnel Council. The other document, P1109, does not list him as a member of the Personnel Council, although it was shown to some witnesses. None of them noted Mr. Salimi's absence from this list or otherwise corrected the document to include him. Indeed, the evidence as to whether the Personnel Council even existed and functioned is also extremely limited, as explained by counsel for Mr. Thaçi yesterday. Now, a subsequent allegation relating to the meeting on the 12th of February 1999, where the prosecution alleges that it was decided to replace Commander Drini as Pastric Zone Commander, has little to do with the Personnel Council. 4752's speculation that it would have been the Personnel Council that provided the reasons for the proposed replacement is not based on his own knowledge. The allegation that Mr. Salimi was supposedly leading the debates at the meeting which led to that is based on one witness's account who could not explain why a separate individual who was also present at the same meeting gave such a different account of this meeting to the prosecution, and explained that neither Mr. Salimi nor members of the General Staff were present or even recalled the witness involved, 4739, having such a public argument with the General Staff members as he had claimed. The defence has addressed in detail the replacement of Commander Drini in paragraphs 446 to 451 of its final brief. The prosecution's attempt in oral submissions on Tuesday to contrast the replacement of Commander Drini and the promotion of Suleiman Salimi is similarly misplaced. The SPO failed to produce evidence that Mr. Salimi was actually responsible in any way for either action. However, the prosecution portrays Suleiman Salimi's election as KLA commander and replacement of Azam Zula, there is no proof that this was engineered or implemented by Recep Salimi. Like much of the prosecution's case, this is merely rumour and insinuation rather than being based on concrete evidence. The SPO also claims that Mr. Salimi was part of a limited group controlling appointments where he ensured that those proven to be reliable implementers of the common purpose received appointments or promotions. Yet this grand statement is predicated on 3 appointments by Mr. Salimi in relation to Faton Mehmetai, that's P1947, Kadi Castrati, P1392, and another individual, P920. Now, despite castrati being mentioned by the prosecution in its final brief, there is no allegation, let alone proof, that this appointment, he is not directly implicated in any alleged crimes. There is thus no allegation or proof that the appointment of him served in any way to implement the common purpose. While Mr. Mehmetai is allegedly implicated in crimes according to the prosecution brief, his formal appointment by Mr. Salimi was in the context of attempts to resolve the situation involving Mr. Tahir Zemai in August 98. Mehmetai's appointment by Mr. Salimi occurred after he had also been fulfilling a very similar role within the Dukajin zone where he'd been appointed by Mr. Haradinaj. P920, relating to a member of FARC, was issued on the same day as the appointment of Mr. Mehmetai. How the SBO can reasonably claim that this appointment, through 920, was also part of a common plan to install Mr. Salimi's loyal individuals to implement the common plan beggars belief. Now, while Mr. Salimi may have wished to exaggerate his role by stating that he personally signed the appointments of the zone commanders of Dukajin, Shala and Lap, that's P774, no witness or documentary evidence to support that allegation has been produced, and nor did the SPO even ask 4746, who would have been in a position to confirm it. So finally, two appointments and their alleged reporting relationships just require a further brief comment. In paragraph 503 of the final brief, the prosecution alleges that Mr. Salimi assigned Nejmi Krasniqi to the command in Prizren, after Krasniqi had overseen prior detentions and abuses in cooperation with Salimi. However, the only appointment in which Mr. Salimi is even alleged to have been involved, concerning Krasniqi's role as the Pastrict Operational Zone Military Police Commander, which occurred in February 99, was extensively addressed and rebutted in paragraphs 247 and 254 to 255 of the defence final brief. In relation to this later allegation, when Mr. Salimi was Minister of Public Order, this was based on the evidence of 4738 in the prosecution pretrial brief, which was not ultimately admitted into evidence. Despite the lack of any remaining evidentiary basis, the SPO, however, continues to maintain this allegation and bridge the evidentiary gap with speculation. And finally, on this issue of appointments, paragraph 1278 of the final prosecution trial brief claims that as the commander of the Eye of the Eagle unit and deputy commander of the Pastrict Zone Military Police, Nezia Krezu reported to the Pastrict Zone Command and the General Staff, including Mr. Salimi. Now, while the defence addressed and disproved any assertion of control over the Eye of the Eagle unit by Mr. Salimi in its final trial brief at paragraphs 423 to 429, the desperate nature of this allegation epitomises the desire of the SBO to show some link between Mr. Salimi and those who were allegedly responsible for crimes in the indictment. There is none. 6. Providing, arranging or facilitating political, logistical, military or financial support. This is paragraph 540 of the prosecution final trial brief. Now this is again the prosecution relying on normal military tasks as a significant contribution to crimes pursuant to a JCE, which I've already addressed earlier. Simply put, they're seeking to find a significant contribution for Mr. Salimi simply by him being a soldier. This is inherently impermissible. However, in paragraph 233 of its final trial brief, the prosecution also, seemingly for the first time, sought to ascribe a political role to Mr. Salimi as well, that set out neither in the pretrial brief or supported by evidence. Although the prosecution appears to accept that Mr. Salimi was not part of the political directorate, it does allege that in May 98 he represented the General Staff in meetings with LKCK representatives where an agreement incorporating such LKCK forces into the KLA was reached, which the SPO characterises as Salimi's foray into political matters. Yet, Mr. Salimi's meetings with the LKCK centred exclusively on military matters. Indeed, in the interview relied upon by the prosecution on this issue, he makes it clear that the outcome of these meetings was the signing of a military technical agreement. Now, despite the LKCK wanting there to be an agreement on both military and political issues, Mr. Salimi clarifies that only a military agreement was made as he refused to speak about the political aspect because that was not his responsibility. That's P1949. And repeated in his Zeri interview at P4200. The prosecution similarly contends that Mr. Salimi's participation in talks with the government in exile's Minister of Defence and Prime Minister in July 98 befits his foray into political activities, again relying on Mr. Salimi's own evidence. Yet the rest of his explanation of that meeting is wholly ignored by the prosecution. He didn't convene the discussion, was not in charge of it, and actually sought to return to fighting back in Kosovo as soon as was feasible. Given the absence of any political meetings after that point, the SPO's assertion that he exercised a political role is entirely untenable. As for the remaining allegations in paragraph 540, again they amount to Mr. Salimi's lawful and legitimate contribution to a war of liberation, rather than any contribution to the commission of crimes. Allegations such as travelling regularly across KLA zones or facilitating operational planning or logistics. In other words, Mr. Salimi was being a soldier. His contribution to the JCE was his contribution to the KLA. A more obvious example of seeking to penalise the mere act of fighting is difficult to imagine. At no point in any of these allegations does the SPO explain how Mr. Salimi travelling across zones actually contributed to the commission of crimes. Similarly, the allegation that Mr. Salimi ensured that JCE members and tools had the resources required to fulfil the common purpose, without specifying which members or tools this is intended to refer to, or what resources he is intended to have provided. Now, you would have thought that the evidence would have come from footnotes, which lists the supposed evidence in support of this allegation. But none have a direct reference to Mr. Salimi. And I would very much echo the comments of counsel for Mr. Thaçi and counsel for Mr. Vaselli in relation to the necessity of digging down into the footnotes in the prosecution final brief. It is replete with anodyne phrases that then are unsupported wholly by the supposed evidence that is cited. These unsupported assertions within the prosecution final brief cannot be unintentional. They must be aware that the evidence doesn't support the existence of a significant contribution by Mr. Salimi to the crimes alleged in the indictment. Yet it does appear to hope that by burying Your Honours in footnotes, this will compensate for the lack of credible and reliable evidence. Now, the final allegation of Mr. Salimi's supposed contribution to the JCE was coordinating and liaising between JCE members and tools. This is paragraphs 541 and 543. Now, while the SPO overstates the importance, nature and frequency of any inspections based on the evidence given in this case, it's also failed to explain how any inspections carried out by Mr. Salimi actually contributed to the commission of crimes. This omission is fatal to their case. Indeed, one aspect of the prosecution case on this final allegation is that because Mr. Salimi was respected and trusted by individuals, this meant he therefore could act as a conduit between General Staff policy and the field. This is set out in paragraph 541. Again, this is based more on hope and speculation than evidence. Mr. Salimi's positive relationships on the ground with KLA soldiers, symptomatic of how he conducted himself, and the fact that he was willing and ready to put his life in danger and fight on the front lines with those individuals, has nothing to do with the alleged JCE attack on opponents. As 4752 testified in the precise extract relied upon by the prosecution, he didn't have any problems with his own commanders because he was accompanied by Mr. Salimi. Not when Mr. Zerapi was doing anything nefarious, but when he was trying to establish defence lines because of the impending Serb offensive. At no stage did the prosecution take the time to explain what the link was between those travels or inspections or good relations with KLA soldiers on the ground and how that contributed to crimes underpinning the alleged JCE. Indeed, it is only the last two paragraphs of the entire section addressing Mr. Salimi's responsibility that the prosecution makes two allegations concerning a concept upon which its case appears to rest. In paragraph 542, the prosecution alleges that as a member of the General Staff, Mr. Salimi formalised command structures, delineated the boundaries of operational zones, carrying the General Staff line on hierarchy, discipline, this is the relevant part, and the targeting of special warfare actors. In the subsequent paragraphs, Mr. Salimi, in relation to alleged visits to Shala and Lap zones, is alleged to have conveyed guidance on identifying and addressing special warfare, explicitly linking political opponents to that category, and instructing local structures accordingly. Now, special war is a concept that's been referred to multiple times throughout this trial by the SPO, as if the mere mention of this term itself is so criminal that nothing more needs to be adduced to explain what it means and how it implicates the accused. Yet the repeated use of this term fails to either define it with sufficient clarity or that this concept was shared by Mr. Salimi and the other accused, or was symptomatic of a common plan against opponents. In paragraph 52 of its final brief, in reference to special warfare, the SPO asserts that this phrase encompassed any type of political discourse or stance perceived as undermining support for the KLA, including criticism of the KLA and its operations, which was cast as misinformation and propaganda. As well as the expression of views considered pacifist or defeatist. And the following paragraph 53 proceeds to allege that included any speculation related to the formation of institutions. Essentially, on the SPO's own case, this phrase was thus so vague, it essentially encapsulated any and all viewpoints which could be interpreted as different from those of the KLA. Its ubiquitousness meant that this term essentially ceased to have any real meaning. It was not a secret criminal phrase, as the SPO insinuates, intended to describe through coded language a specific agreement to target opponents. Instead, it amounted to shorthand for any number of different topics. Any passing reference to this concept without information or explanation as to its meaning, purpose, and what it specifically related to in those circumstances is evidentially meaningless. Your Honours, I think I have about 7 minutes left, so with your indulgence, thank you very much.
Go right ahead.
Thank you, Your Honours. I would just like to move now to the issue of intent. And this is where I will end my submissions today before my colleagues take over in the morning. And when I say the issue of intent, I mean the lack of proof that Mr. Salimi had any intent to commit the crimes charged in the indictment or to participate in the common plan involving their commission as alleged by the prosecution. Now, the prosecution's generic assertions that the accused's roles in the formulation, implementation, and enforcement of the common purpose directly demonstrates their intent to participate in it and to commit the charged crimes have already been discussed in detail, as have the SBO's reliance on the existence of the alleged common plan and the alleged significant contribution of each of the accused to it, including Mr. Salimi's alleged involvement in the incident in Klečka. Now, without evidence that any of Mr. Salimi's actions amounted to anything close to significant contributions to a JCE, no reliance can also be placed on them to somehow discern intent on his behalf. Instead, the prosecution relies seemingly on three separate uncorroborated allegations, or two separate uncorroborated allegations, to demonstrate his supposed intent behind the JCE. First, one uncorroborated and very convenient allegation of a supposed threat by Mr. Salimi to an individual. I believe this is in relation to a transcript dated 26th of June 2024, which was relayed by a discredited and wholly biased witness who falsely blamed Mr. Salimi for the death of his relative. The defence contests whether that was ever said, and no weight can be given to that evidence by the panel. Nor can any weight be given to an alleged threat by Mr. Salimi to Commander Drini, allegedly overheard by a witness whose identification of Mr. Salimi was again deeply flawed, especially when the prosecution neglected to call as a witness the actual person to whom this threat was supposedly made, despite originally listing him on their witness list. Two uncorroborated, unbelievable, and fabricated instances do not demonstrate intent on Mr. Salimi's behalf. Instead, all that the prosecution has to supposedly establish Mr. Salimi's intent for the JCE is the speech that he gave at the KLA's first public appearance in November 1997, which is specifically relied upon in paragraph 573 of the SBO final trial brief. How ironic it is that of all the words spoken before, during, and after the indictment period, of all the allegations made against the accused, and the reasons why this tribunal need to be created, the well-known speech at the funeral of the murdered teacher, Halil Getzi, that galvanized support for the KLA and introduced the KLA to the public for the first time, is where the SBO's case against Mr. Salimi ultimately rests. Now, while the defence has already addressed in the final trial brief the circumstances through which that speech was written, it does not refer to any of the FARC, the LDK, or Bukoshi's government being collaborators. As a classic piece of propaganda befitting its purpose in the circumstances of the time, it highlights unspecified actions that have been taken against collaborators and collaborationists, and legitimately criticizes those who believe that war was not the correct policy to pursue. This is not emblematic or demonstrative of intent by Mr. Salimi that crimes be committed against opponents. It was intended and directed to inspire resistance. It was intended to show that only through fighting back against those forces who had killed, raped, and tortured the Albanians of Kosovo would liberation be achieved. Its success can only be judged by those hundreds and thousands who volunteered to fight for the KLA in the weeks and months that follows. Your Honours, thank you very much for your attention. This comes to the end of my submissions, and I'll pass over to my colleagues in the morning.
Thank you very much. Just for some guidance, tomorrow we will probably finish with your colleagues' portion by noon. For the Krasniqis, defense's information. We will probably break for lunch right then at 12 o'clock, go until 1:30 with the lunch break, and then start up, and then you would have the rest of the afternoon and would nearly be finished in that time period, but we'll have Monday as well for you to finish up in. So that'll be the plan for tomorrow, and we'll outline it in more detail in the morning. Anything else? We're adjourned until 9 a.m. tomorrow.
All rise.